Call to order the meeting of August the 10th, 2016 of the Colorado Independence Ethics Commission. Mr. Ioannidis, if you can take the roll, please.
Commissioner Bacon.
Here.
Commissioner Jones. Here. Commissioner Smith.
Here.
Mr. Chairman.
Here. All right, we have a forum and we have a full house. As I understand it, we have made arrangements for live streaming of our meeting today. Is that right, Mr. Ioannidis?
Yes, Mr. Chairman, we have, in conjunction with Open Media Foundation and State Internet Portal Authority, we're piloting streaming today. It is video streaming. The link is available on our website, and I will be presenting a little bit more about that to you later.
Okay, and can you introduce us to our videographer so we know what to call him if we need to?
Sure. This is Brandon. Brandon, forgive me, I've forgotten your last name. Brandon Stiller.
All right, Brandon, this is our pilot run with our video streaming, so there will be times during the meeting today when we need to go into executive session. It should be pretty clear to you when that happens. When that happens, we'll be asking you to shut down the stream, the feed, and the camera, and we're going to rely on you to make sure that's done. And Mr. Ioannidis will go over and check with you to make sure that that's been effectively done so that we don't accidentally compromise our need to be in executive session, okay? You got that? And if you have any questions about that, feel free to ask us. We answer questions readily, okay? Okay. Then I've heard some voices on speaker. Can we have those who are, who are listening to the meeting by phone remotely, identify themselves, please?
This is Greg Giel.
Okay.
Stephen Keno.
I'm sorry, can you repeat that name and spell it for us, please?
Stephen Keno. Keno.
Okay, and where are you located, Mr. Keno?
Pagosa Springs.
Okay. Anyone else? I don't hear anyone else. A moment ago, I thought I heard reference to a courtroom. Is there, was that a reference? Mr. Gill, was that you talking? Were you talking about our hearing room here in Denver?
Oh, I was just letting Keno know that we were on the speaker in the hearing room.
Okay, all right, good enough, all right. So let's move through the agenda. First item of business is public comment. We always put that first on our agenda. We have a large group of people, maybe 15 or so people here. What I usually ask is if you have a public comment that has something to do with one of our agenda items, that's a specific agenda item, and you're here for that, and you're interested in that, we generally save public comment for that agenda item until we get to the agenda item. It's easier for us to deal with it all at once. So, for example, if you're here for the home rule issue, which is item 7 on our agenda, then we'll make sure that we give interested members of the public an opportunity to comment about that item when we get to it. Same thing is true with the various complaints and other items on the agenda. So with that understanding, do we have any members of the public that want to make a comment before we start into our agenda? Yes, sir, and if I could just ask you to identify yourself and I suppose step to the podium and use the microphone since we are streaming.
My name is David Kofelt. I live here in the Metro Denver area. I wanted to find out if there is a handout for this public items of interest that we can review and see how this program is going to go. Is there a handout?
I'm sorry, which program? Are you talking about this meeting?
Yes,
Yes, on our website, the agenda is posted before every meeting.
but you don't have a paper handout right now so we can review it.
I don't know, do we have paper copies of the agenda?
I do not, Commissioner.
Okay, thank you.
Do you, it looks like we at least have one person that has a paper copy of the agenda, and so she's going to get some copies maybe and have them for us in here if we need it. How's that, Mr. Kofelt?
Thank you.
Okay. What else? Anyone else have any comments or things they want to raise to us before we start into our agenda? Yes, sir.
My name is Stephen John Nalty. That's spelled N-A-L-T-Y. I was born in Denver a long time ago. I live in Denver now, as well as in my body. I have become increasingly aware over the last several years that there is a tremendous propensity for judges to legislate from the bench, for attorneys to legislate from their offices, for prosecutors to legislate from their tables, and for law enforcement personnel to legislate from their patrol cars. I'm very concerned about this and am aggressively working on actions to stem the tide of it because all of it is unlawful. Thank you.
Thank you, sir. Anyone else have any comments that they'd like to make? Seeing no hands and seeing no additional public comment, we'll move on to item 2 of our agenda, approval of the minutes from the July 25th, 2016 meeting. Is there a motion or discussion? Commissioner Smith.
Thank you, Mr. Chairman. I'd move the adoption of the minutes from the July 25th, 2016 meeting.
Second.
It's been moved and seconded that the minutes from the July 25th meeting be approved. Is there any further discussion? Hearing none. All those in favor of approving the minutes from the July 25th meeting, say aye.
Aye.
Any opposed? There being none, the minutes are approved. Third item on our agenda today is a public hearing for complaints numbers 1531, 1532, 1533, and 1534. And I see seated at the table in front of us, Mr. Gruskin, and with you, I assume, is Mr. Starr. And on the phone, we've heard Mr. Giel identify himself. So we're ready to start that public hearing. Let me start by, we had a pre-hearing conference on this at the time of our last meeting, and we got some things squared away. And just to fill in the other commissioners, I think during that hearing, you appointed me or delegated to me sort of pre-hearing authority to deal with pre-hearing matters concerning this. While I appreciated that, I didn't have any pre-hearing matters to deal with. Things have been very quiet since our last hearing. I think you can see in your materials that the parties have submitted additional information. We have a pre-hearing brief from Mr. Gruskin. We have a pre-hearing statement, I will call it, from Mr. Giel. We had invited him to submit his comments in writing. Mr. Giel submitted some copies of letters and agendas and things like that to support his assertions. Mr. Gruskin included some exhibits for his side. And I think what we said at the last hearing was that we would start the hearing by hearing argument essentially from both sides based on the facts set forth in our own executive director's report, and that we would then make some determination after we hear that argument about whether it's necessary to receive any live testimony. So with that, Mr. Gruskin, if you'll bear with me, I think we had made a decision last time that live witnesses needed to be present in the courtroom or in the hearing room, and that we would not allow cross-examination remotely. But I think we did leave open the possibility that we would allow Mr. Giel to be heard from and make his arguments to us. And so I think I'd start with that and afford Mr. Giel an opportunity to make his statement for the record. Is that all right with you, Mr. Gruskin?
Mr. Chairman, I think that's totally reflective of the direction from the July 25th meeting, and we have no objection.
Okay, and as always, if any commissioner thinks this is the wrong procedure, they will correct me immediately. So, Mr. Giel, are you able to hear us pretty well today with our microphones that we have set up?
I am, as long as people speak to the microphone. I actually went on the website, and I do have your streaming up on the screen, and the videographer could either pan out, or he actually needs to be, all I can really see is the back of Starr's head and the four people on the two people to your left and the one to your right.
That's how it's supposed to be.
That's probably okay. I think that's the way we want it. The purpose of the stream is so that members of the public can see the commission, see our deliberations. And so unless there is a need to, like let's say we had a witness and you wanted to see the witness testifying, then we would figure out what to do about that. But for now, let's go ahead the way we are. But you're able to hear us, okay, as long as we speak to the microphone? Is that what you're saying?
Yeah, as long as people speak toward their microphone, yes.
Okay. All right, well, let's start with you. I'm not going to put a time limit on your opening statement, but I would ask you to be respectful. I think we have 20 people, 25 people here today and a number of items on our agenda, so I'd ask you to be respectful of their time. So why don't you lay out for us as succinctly as you can, Mr. Giel, what it is that you want us to know about your complaint in this matter.
Okay, so I think that the document that I prepared for you and submitted on August 3rd sums the whole thing up very well. I'd like to start with a quote from Thomas Jefferson. In questions of power, let no more be heard of confidence in man, but bind him down from his mischief by the chains of the Constitution. And then I'd like to take a part out of Bovier's Law Dictionary, 1856. Colorado became a territory in 1861. This is statute. Number 4.1, public statutes are those of which judges will take notice without pleadings, as those which concern all officers in general. Basically what we have here, and like I said, that document that I've prepared and submitted is everything very succinctly. I'll be here for any questions, but basically we have a former employee contract that was made before he even terminated his employment. What brought my attention to this whole thing was the November 5th, 2015 editorial about this issue that was submitted by the retired judge, James Denver. And literally it was that editorial that got me really wondering about what was going on with Starr's contract. So, without beating a dead horse, literally that's what we're dealing with.
Okay.
Former employee's contract, it was less than 6 months. There are state statutes involving procurement, and there's a county procurement policy, and they were completely ignored. There's definitely a conflict of interest, serious conflict of interest here involving Mr. Starr. So I'll leave it at that for now, and I'm here to answer any questions.
Okay, thank you, and we do have your written submission from August 3rd, and so we have that in front of us, and we will come back to you with questions if we have any. Mr. Gruskin, would you like to respond?
Thank you, Mr. Chair. This process, your process, is one of accountability. It's about holding public officials accountable, elected officials and appointed officials and government employees, based upon ethical codes in the state of Colorado. But you have a second mission as well that also revolves around accountability, and that's this. If a complaint is filed, there have to be specific facts, and there has to be a specific statute that links with those facts like a puzzle piece, comprising a violation. And that means that you have to consider the entire statute, the proposed violation, the exceptions in the statute, and the definitions, which change an interpretation of a statute such that it may not apply. And the example that leaps to mind, of course, is the state procurement code. But you have to use that level of accountability on a complainant, because what you're dealing with here is the reputational interest of the respondents. And I guess I thought he was an old lawyer when he said this to me, but I kind of now think of him as middle-aged. Once said to me, you only have one reputation. And that reputation is what you're litigating here today. we would suggest to you that the burden of proof is most certainly on the complainant, and that he hasn't fulfilled that burden. But I'm not asking that you simply dismiss this complaint. I'm asking that for months now, the names of the 4 respondents, Todd Starr, Clifford Lucero, Michael Whiting, and Steve Wadley, have been besmirched by claims that they violated ethical codes at the county and the state level. And I'm asking that you find that they did not violate any ethical code, not simply that there was a technical deficiency, although there are many on the part of the complainant. There simply isn't a legal claim that is warranted here. As the commission knows, when the complaint was first filed, you had to allocate to staff the responsibility to discern what statutes actually could apply. But even then, staff in its factual investigation and its legal assessment found only that there were statutes that could be implicated. And even as to the local procurement policy, only the ethical aspects, according to this commission's ruling, could be considered. So the question is, has the complainant produced any evidence that that puzzle piece of a statute, the prohibition, if it exists, the exceptions, if they exist, and the definitions, if they're pertinent, have in fact comprised a violation? And I'd suggest to you that they haven't. And as tempted as I am, like most lawyers are, to regurgitate their brief just in case you didn't read it, I know you did, and I'm going to repress that inclination, kind of.
Good, because we kind of read your brief.
Okay. Fair enough. I'd like to run through, even though the complainant hasn't done so, I'd like to run through the statutes isolated by staff, because they relate directly to your responsibility and I think your ability to find that these 4 public officials, 3 elected and 1 operating as a government employee until September 21st, did not violate any of these provisions. But I would first note, Mr. Chairman, as an add-on to what happened on July 25th, it was my understanding that the commission decided that of the factual representations in the staff's investigation report, unless they were complained of as being inaccurate, they were going to be taken as stipulated facts for purposes of this hearing. And to that end, notwithstanding an outreach to the complainant, there were no other facts that he chose to stipulate to. But we have set forth in our brief, we think, all of the pertinent facts that allow you, based on the understanding that they are now stipulated facts for purposes of this hearing, that you need to consider. I would say this, though, and I will offer as an offer of proof, that there are other factual issues that we would develop through live witness testimony if it's of relevance to the commission, and they are this. Number 1, there is no other attorney in Archuleta County who has the requisite skill set to provide the composite skills and legal product that Mr. Starr does. That those skills include, as a matter of practice of law, being a transactional attorney, having a command of administrative law, having a command of election law, having a command of property tax law, having a command of federal aviation law, having a command of road and bridge related laws, being a contract attorney, being a HR, a human relations attorney, among others, because the role of county attorney, we would establish, if there were question, does not simply involve advising the commissioners. It involves advising every county agency that exists. We would also prove, if it comes to that a key aspect of being able to function well as a county attorney is having a familiarity with the county, with its economy, with its topography, with its population, with the issues in front of it that you simply can't contract out. You can't offshore this kind of legal service effectively. Fifth, we would establish through testimony, as we believe we have done in writing, that the cost savings to the county are upwards of 30% of the contract price itself, the actual cost that that was incurred by the county when Mr. Starr was an employee. And that, in fact, that was based upon budgeted numbers. Mr. Henderson, who's the county administrator, would testify that, in fact, there have been actual savings, not merely budgeted savings, reflective of that amount as annualized for the entire year. Sixth, we would establish that the county did, in fact, consider cost savings, as well as experience, continuity of service, and knowledge of the community. Seventh, we would establish that Mr. Henderson, as county administrator, both negotiated the terms on behalf of the commissioners with Mr. Starr and recommended to the commission the adoption of the contract. Additionally, we would establish that there has been no double billing, as alleged most recently by Mr. Starr, to benefit either him or his law firm. And lastly, we would establish that there have been no ethics violations because Mr. Starr performed the obligations required of him under the county's procurement policy. Even without those facts, we believe that the stipulated facts that appear on pages 1 to 3 of our brief, facts 1 through 25, are sufficient to allow you to determine that none of the 7 areas of law identified by your IEC staff have in fact been violated. Let me attack them briefly. Number 1, there's Colorado Revised Statutes 24-18-103, paren 2, the breach of fiduciary duty statute. That discussion, and I will just highlight it for you so that you can either read or listen, you don't have to do both, appears on pages 5 and 6 of my brief.
Could you hold on just one second, Mr. Grusin? Mr. Ioannidis, where do we find that in our?
So if you go to the list of documents, in the upper left-hand corner, if you're using Adobe, you will find kind of a home button. If you click on that, then you will find a list of documents that you can go to. I can come and show you where that's done. And at any rate, the Title 24 documents are in there. Let me come show you.
I was actually looking for Mr. Grusin's brief.
It's on the list.
Yep, respondents hearing brief.
Got it. Okay, good enough. Sorry, go ahead, Mr. Grusin.
No, it makes for fascinating reading.
I apologize for interrupting.
No, that's fine. It allowed me to get a drink of water. So the fiduciary duty statute imposes an obligation for one who acts as a trustee of property. So the question is, was Mr. Starr a trustee of property? There's no factual allegation. There's no evidence before you that he was. Were the commissioners a trustee of property? Well, only arguably. But the point is, we can establish that there are cost savings to the county because of the fact that Mr. Starr, who resigned on September 21st, and who then became a member of a local law firm, started a local law firm that has an office out of state, actually saved the county money, saved the county tens of thousands of dollars. Our estimates are someplace between $50,000 to $70,000 worth of savings to the county on an annual basis. How is it that you violate your fiduciary duty to act as a trustee of property if you not only conserve the property, but if you enhance the capacity, in essence, the buying power of those taxpayer dollars? You cannot violate that statute. If the county is better off financially after the fact than before the fact. And there are a number of other arguments that I raise as to why you'll have to go through a fairly severe legal analysis about whether this is a fiduciary, whether there is a duty, to whom the duty runs, the fact that Mr. Giel's going to have to establish that he, in fact, was harmed and that there was a violation of the duty, but he was harmed by the violation of the duty. We don't think that you can establish that anyway, but you certainly can't establish it in light of the fact that there were fewer taxpayer funds by tens of thousands of dollars being spent now than there were before. The second statute is Colorado Revised Statutes 24-18-1041A. And for those who might also be reading online or otherwise, that appears on pages 6 and 7 of my brief. This statute provides that a covered official shall not disclose or use confidential information acquired in the course of his official duties in order to further substantially his personal financial interests. The complainant doesn't say that this actually happened. The complaint doesn't really allege this. This is a statute that understandably was isolated by staff, but there's no factual basis to say that Mr. Starr, as a member of a law firm, has used or disclosed information to further his personal financial interests. The fact that he became part of a law firm is irrelevant. The question is whether or not, even by contracting with the county, he furthered his own personal interests. And the facts would also show that Mr. Starr isn't an equity owner of this law firm, and therefore it would be impossible, just because the law firm has a contract, for him to directly benefit. But the point is, that's kind of the technical reason why this isn't a violation. The real reason is that Mr. Starr used confidential information that he had before he left county employ. He did use it afterwards for the benefit of the county as an attorney. And therefore, the purpose of this statute is to make sure that people don't, in essence, sell their experience or sell their knowledge so that government is undercut. There's no showing, there's no allegation even, that government was undercut by the fact that Mr. Starr provided exactly the same legal services before and after the time that he left the county employment. If there's not an allegation and there's not evidence, you have to find that the commissioners and Mr. Starr did not violate this statute. In any event, this is one of those statutes, and there are several, as we note in our brief, where the legislature has said you have to find a violation beyond a reasonable doubt, not by preponderance of the evidence. So the fact that there hasn't been any allegation, there hasn't been any evidence, undercuts the complainant's position, but the fact that he would have to prove that beyond a reasonable doubt, I would suggest to you, makes it that much of a steeper climb for him. The third statute is the so-called revolving door statute. Colorado Revised Statutes 24-18-105-3 prohibit either an official or an employee within 6 months from obtaining employment in which he will take direct advantage unavailable to others of matters with which he was directly involved during his employment. What is that statute about? That statute is about taking inside knowledge and giving it to somebody that the county or the municipality or the state does business. That's about changing sides. And there's no allegation that Mr. Starr changed sides, just the opposite. He continued within 6 months to take direct advantage, if he in fact did take direct advantage, of matters in order to represent the county, not to undercut the county. And this statute cannot possibly be read to apply to the person who does the exact same job on behalf of the public entity that he did before. In any event, there is no proof that Mr. Starr entertained any direct advantage because of his employment. There's no suggestion that the only reason that he left the county's employment was in order to represent them outside of the county. In fact, the resignation letter, as which is one of the exhibits which we have provided to staff and which is part of your packet, establishes that he's leaving the county's employment anyway. And so this was a mere incident. You would have to establish, as we point out in our brief, that there was some sort of private client application, claim, or contested case that Mr. Starr provided information that worked to the disadvantage of the county. In any event, I would remind you that this statute, as we point out in our brief, says that it is merely advisory only. It said these particular guides of conduct do not constitute violations of the public trust. And therefore, this claim isn't even properly before you. Fourth, Colorado Revised Statute 24-18-109 2B, dealing with economic benefit and addressed in our brief on pages 8 and 9, provides that a government employee, a local government employee, shall not perform an act directly and substantially affecting to its economic benefit a business or other undertaking in which he has a substantial financial interest or is engaged as counsel. Here's one of those definitional issues. What is an official act? Well, fortunately, the statute is very clear about that. It's a vote, decision, recommendation, approval, disapproval, or other action, including inaction, which involves the use of discretionary authority. And so what was Mr. Starr's discretionary act? Because the evidence will establish that it was Mr. Henderson who negotiated and recommended the contract to the commission. And Mr. Starr had no vote or approval or disapproval on the agreement. And there's no suggestion that the three people who did vote on the agreement had what the statute requires, which is a substantial financial interest in that contract. There simply is no violation here. Fifth, the one statute that actually was referred to in the complaint is Colorado Revised Statutes 24-18-201, dealing with former employee contracts, which provide, among other things, that a former employee may not, within 6 months following the termination of employment, contract or be employed by an employer who contracts with a state agency or local government involving matters with which he was directly involved during his employment. Again, this is one of those statutes that's all about protecting government, right? Keeping the interests of government inviolate, at least for 6 months, having a cooling off period, so that you don't switch uniforms in the middle of the game. Well, there's no suggestion that Mr. Starr switched uniforms. He didn't go represent a sand and gravel company that was contracting with the county. He didn't represent a litigant who had a claim against the county. He didn't represent a candidate who was contesting the election result of the county. He represented the county before and after. But even if you don't look at the plain import of the statute, in your previous advisory opinions and letter rulings, you have deferred to the public entity. You have said, absent clear facts to the contrary, you will defer to the public entity to determine whether or not there has been a potential conflict of interest or violation of a duty of loyalty by an employee to the public entity for which he or she worked. And clearly, this county determined that there was no violation of a duty of loyalty or a conflict of interest by the fact that they agreed to continue that relationship, albeit in a different form. Even if you're not going to look at what the statute does in the real world, look at what the statute says it's supposed to apply to. And that's one of those exception issues that I mentioned a little earlier. This is not a contract. Like it or not, for this statute, this is not a contract. And the statute is quite specific on two different grounds. Number one, Our revised statute, section 24-18-201B, Roman numeral 4, says that a contract does not exist where, due to geographic restrictions, a local government could not otherwise reasonably afford itself of the subject of the contract. Well, both in terms of the stipulated facts and in terms of the offers of proof, we've established that there was not a cost-effective option for Archuleta County to replace Mr. Starr, certainly not in the way that it would have been in the interest of the county. But the statute goes on to say, if, because of those geographic distributions, you have to spend 10% more than your existing, or than what you plan on in terms of a contract with someone from outside of this statute's coverage, it's okay. So you can spend the contract price plus 10% and still be consistent with the statute where these geographic distributions exist. Well, guess what? Archuleta County didn't need to go to the $230,000 it had allocated for its county attorney budget and add 10%, which would have been over $250,000. Instead, they were able to save more than $70,000 in budgeted and realized expense. So this just isn't a contract. It just doesn't qualify under the statute. The substance of the statute never becomes relevant. But the second reason why this isn't a contract is that it isn't a contract if the employee has disclosed a personal interest and has not voted thereon. Guess what? Mr. Starr doesn't get to vote on his own contract, only the commissioners do. Or with respect to which any member of a governing body has voted and made disclosures. Well, guess what? These commissioners don't have any interest in the contract. So they were able to vote. Mr. Starr was able to continue to be county attorney without invoking the statute. All right, we're narrowing in on the end here. I say that for my purposes, not yours. There are two procurement codes before you. One is the state, one is the county. The state simply doesn't apply. It doesn't apply because by its terms, it applies to the executive branch of state government. And that's all it applies to. It doesn't apply down the road to the counties or to cities or to districts or to anything else. And all of the purposes of the statute are framed, as we point out in our brief, are framed in terms of the state of Colorado. Procurement by the state of Colorado, the procurement system of the state of Colorado, public funds of the state of Colorado. The state procurement code just doesn't apply. Now, the complainant in his responsive documents cited to you 24-103-205 about sole source government contracts. And that is a statute that deals with sole source procurement. But under the statute, it says that there can be sole source contracting when the executive director, the head of a purchasing agency, or a designee of either of them authorize it. Well, the executive director and head of and purchasing agency are defined terms. At 24-101-301, paren 9, executive director is defined to mean the executive director of the Department of Personnel. And under sub 8, department means the Department of Personnel. So it only relates to the state. But also under that statute, 24-101-301-11, head of a purchasing agency means the director of a purchasing agency created under state law and the principal authorized to engage in certain capital construction. Well, both of the statutes referred to make it clear that it is the executive director of the Department of Personnel who triggers the appointment of the head of a purchasing agency. So even the sole source provision that is cited to you in the response documents by the complainant, by their terms, if you read the definitions, apply only at the state level. The state procurement code simply doesn't govern the activity of local officials. So let's talk about the code that does. The Archuleta County Procurement Policy is a 50-page document. This commission decided that only the ethical aspects of the procurement policy were relevant for your purposes. And honestly, I undertook an exercise that points out how haphazard this complaint is, which is that I had to identify the provisions of the Archuleta County procurement policy that could be implicated, and then I had to build the defense around them. It wasn't very hard, but it was still a little bizarre that I had to create the case and then disprove it. So let's talk about the case. There are only 3 possible provisions that apply. One deals with whether or not contracts are competitive. The second is whether or not there could be any subjective favoritism. And the third is the one that requires strict adherence to the conflict of interest policy provision. You need to take a look at definitions again. I hate to sound like a technician, but it doesn't work without taking a look at the definitions. The Archuleta County procurement policy allows contracts without going to bid if one firm, only one firm, is in a better position to provide certain services. And the provision referenced on page 13 of our brief talks about services that include professional or consulting services, both of which are defined under the procurement policy, and both of which refer to either legal counsel or legal services. So undertaking the sole source contract here was totally authorized by the procurement policy, and in fact, these services weren't subject to those other provisions, which ought to be enough, but it's also important that that last issue, the conflict of interest issue, specifically says, and this is on page 14 of our brief, that due to the nature of the small rural community of Archuleta County, it may not at all times be feasible to exclude local vendors from doing county business, as described hereunder. And it allocates specifically to the county attorney making this decision. Well, it's already clear that there not only were not a lot of attorneys who could provide that range of services in Archuleta County, there was really only one. And so it qualifies under the exclusion from sole source contracting. But the point is that Mr. Starr undertook an assessment that this was an appropriate contract to be bid to a local vendor. And therefore, there was compliance with the conflict of interest requirements. All right. The good news for you is that I'm on page 15, and there's only 15 pages in the brief. What I want to say is that I know you understand the gravity of your position in terms of litigating the reputations of people who are going back to a community and live with that reputation in that community. It is one thing to entertain a complaint. It is a wholly different thing to find that there is, without facts and without law, a violation under that complaint. And I would ask you, having deliberated on this, and you've reviewed a lot of procedural issues over the past several months, so I know that you take it seriously, I would ask you to find that not one of the respondents violated any one of the grounds that have been identified by staff. And as a function of this, the complaint should not just be dismissed, but denied with prejudice. Thank you.
Does anyone mind if I go first with some questions and some clarifications? Mr. Gruskin, let me start with you, and Mr. Giel, keep listening because I suspect I'll be bouncing back and forth from one to the other here for a minute. Let me start by making sure that on a couple of factual issues. I think when we initially authorized a procedure here, a hearing, we made an initial and very preliminary determination about the complaint. One of the questions that we had was this potentially a situation where Mr. Starr, as county attorney, had made decisions as county attorney to send work to this law firm in advance of his joining, in effect referring work and then cashing in on those referrals by joining the firm. Is my understanding from our investigation that is absolutely not the case. Is that right?
You are correct, Mr.
All
Chairman.
right, so that this law firm did not receive engagements or fees from the county before Mr. Starr joined?
Yes, and I'll add to the offer of proof that the county made no payments to the Rose Walker Starr Law Firm until January 2016. I'm sorry, to Rose Walker.
Is this
To Rose Walker.
question,
To Rose Walker Starr. Now, his employment commenced October 22nd, based upon the stipulated facts, and Mr. Henderson would testify that the county didn't make a payment until January 2016. And so there was no retainer, there was no hourly, there was no transfer of any money.
Okay. Mr. Giel, is that consistent with your understanding of the facts that the Rose Walker firm was never retained by the county before Mr. Starr left his position as county attorney?
okay, you're speaking in lawyer talk. Say that again?
Okay, so is it your understanding as well that before Mr. Starr went to this law firm, in other words, while he was acting as county attorney, while he was employed by the county, is it your understanding that he did not hire this law firm for the county while he was still working as county attorney?
Well, no, the commissioners handed him this contract, and it helped him open that office. That office didn't exist until after they handed him this contract.
I understand that. I think we all understand that, and I'm going to get to that in a minute, but you don't have any reason to believe that for 2 months, 3 months, 6 months, 12 months before Mr. Starr left the county attorney's position, that he was sending work to this law firm before he joined it?
Without any billing statement in front of us, I can't answer that. We're just going on whatever Gruskin's saying and whatever somebody else is saying. There's no billing statement in front of you for hours that Starr might have turned in. I don't know.
Okay, well, we don't have any information before us that would suggest that that was the case. So that was an important question for us to have answered early on.
Mr. Chairman, if I just could, I may have gone to the next, I answered your question with the next answer, but the direct answer to your question is no, Mr. Starr didn't send any business while he was county attorney or even otherwise to Rose Walker Starr for any purpose while he was a county employee.
Okay. And Mr. Gruskin, let me ask you a couple of questions, and I'm going to start at the top of your list. You started with the statute that relates to a breach of fiduciary duty.
Correct.
And I noted, it seemed to me that you had a couple of arguments there. One felt technical to me, and that is that a fiduciary within the meaning of the statute is someone who's is a trustee of property. I'm going to set your technical argument aside for a minute. I think one of the things that we as a commission try to do is not interpret statutes in any sort of breathtaking or broad fashion that might have implications later on. So let's assume for a minute that Mr. Starr, as an attorney for the county, while he was working for the county, had some form of fiduciary duties to the county as an attorney, and that even in his capacity as outside attorney for the county, had some form of fiduciary duty for the county. So let's just assume that for a minute. my experience tells me that there are 4 components typically listed as being components of fiduciary duty. One would be candor. Is there any dispute in our case, and I'll ask this first to Mr. Gruskin, then to Mr. Giel, is there any dispute in our case that Mr. Starr was completely transparent with the county, with Mr. Henderson, about his interest in continuing to represent the county, the firm he was going to be working for, the fact, obviously, that he was involved with this firm before Mr. Henderson and the board made the decision to retain the Rose firm to represent the county?
No, there's no suggestion of a lack of candor about his plans to leave the county and his openness.
Okay. So this is not a situation, I could draw a contrast. This is not a situation where, for example, Mr. Starr stood by silently and sort of nudged the commissioners to retain a law firm without telling the county commissioners that he was going to be joining that law firm.
No, he was absolutely upfront at all points over that issue.
Okay.
And all others.
Mr. Giel, you understand that distinction I'm drawing? Do you have any?
Yeah, I actually have an answer for you.
Okay, and what is your answer?
Go to the investigation report, page 4. Clifford Lucero, in paragraph 9, admits he was assisting advancement of Starr's career. Investigation report, page 6. Steve Wadley, interview, paragraph 5. Wadley admits Starr's offer to come on as a contractor. Wadley goes on to admit to discussion about Starr making more money, acquiring the county as a client for his new firm.
I understand, Mr. Giel. Mr. Giel, we're going to get to that.
All three of the commissioners admit right in their testimony to Dino that they knew exactly where he was going and what he was going to do.
Mr. Giel, I understand.
They all admit helping him do it.
Okay, that answers at least one of our questions. What we're focused on right now is whether there was any information withheld from the county as part of Mr. Starr's exit, and what I'm hearing from both of you is that there is no indication of that. So my next question that I have for you, Mr. Gruskin, is the sort of the second part of fiduciary duty, as I understand it, is honesty. Is there any indication that Mr. Starr made any kind of misrepresentation whatsoever to anyone at the county in connection with his leaving his employment, going to a new firm, starting a new firm?
None.
Okay, Mr. Giel, are you aware of any such, I don't see an allegation in any of your materials that there were any misrepresentations or falsehoods made by Mr. Starr to anyone in connection with his work?
I have a question, and I need this clarified before I can give you an answer. Are we dealing with just whatever Starr did in the past, or are we dealing with whatever Gruskin is presenting right now?
We're dealing with Mr. Starr and his departing from the county and entering into a new relationship as outside counsel for the county. The question is, do you have any reason to believe that Mr. Starr made any kind of misrepresentation to the county that was related to that event? That event.
Only that there was a conflict of interest, that he shouldn't have advised anything in the creation of this contract.
Okay. And Mr. Gruskin, I take it from you.
Wait, conflict of interest.
I understand. I'm going to get to that. It's just going to be one kind of baby step at a time here. I want to go down the list of standards here and make sure that we've covered them all, and so that Mr. Ioannidis, as he drafts whatever we end up voting on, will be able to capture the points. So let me, let's see, I was interrupted there for a minute, so let me regain my train of thought for a minute. I'm going to jump to your last point for a minute here, and this was Mr. Gruskin, a point I didn't quite understand. under the Archuleta County procurement policy, there was a part of your brief where it said something like, the Archuleta County officials could not strictly adhere to the policy by allocating to an official other than the county attorney the responsibility for determining the ethical propriety of contracting for legal services. So I just want to make sure I understand that. You're not saying, are you, that Mr. Starr was asked to issue an opinion to the county in his capacity as county attorney about the ethical nature of whether the county could, in fact, retain him as outside counsel? You're not saying that, are you?
There was no official opinion rendered. The point in that part of the brief is only that if there was a conflict of interest, alleged that it would have been only Mr. Starr who, under the policy, could make the decision of whether or not a conflict of interest existed.
Well, if the county commissioners had wanted to seek outside counsel about this contract with Mr. Starr and get the opinion of another attorney about whether it was a good idea or a bad idea, whether the fees were reasonable or not feasible, was there anything that would have prevented them from doing that?
Nothing structural that would have prevented them from hiring outside counsel.
Okay, and I'm guessing from all the materials that have been presented that Mr. Starr's role in this negotiation was he disclosed to the commissioners that he was leaving, he told them where he was going, he indicated he was interested and willing to continue to represent the county as an outside attorney. I'm going to assume that he proposed to the county, what the terms would that be, how much would be paid, and what the terms and conditions of that would be. And then the county then was free to designate someone to negotiate with him about that contract, and that was Mr. Henderson.
Correct, on all
Okay.
fronts.
And Mr. Henderson could have sought outside counsel on that had he so desired.
That's correct.
But Mr. Starr did not purport to be essentially representing both sides of that negotiation. He wasn't negotiating for the county and negotiating for him and his new law firm on that contract.
Correct,
Is that the way it happened?
yes.
Mr. Ioannidis, anything you learned in your investigation that would suggest otherwise?
No, Mr. Chairman.
Okay. The second point that you spoke to, Mr. Gruskin, was use of confidential information. And you cited us to Title 24, Section 18104, that provides that I'm going to try and kind of leave out some words to make it make sense for this context, but that an employee, a government employee, shall not disclose or use confidential information acquired in the course of his official duties in order to further substantially his personal financial interests. And I think that you indicated that you believe that the intent of that was to prevent an employee from, let's say a government employee learned that the government was going to build a convention center or an arts center in a particular location. And before that information was known to the public, the government employee would go out and buy land in the vicinity of the convention center to make a personal profit. Is that the kind of thing that you're anticipating?
Correct. I think that would be the use of the information. Likewise, if that employee went to a local developer and advised that he, she, or it went and bought that parcel so that they could profit, then that employee would be disclosing that confidential information, assuming, again, that the purpose was to further substantially the former employee's economic interests.
All right, and so a couple of things about this. Sometimes it's easier for me to work through an example for a minute, and then that helps me understand the statute. So in the case we've been talking about, first of all, the information would have to be confidential. It would have to be secret.
Right.
Secondly, the employee would have to have received that information for one purpose. I guess in our case here would be for Mr. Starr would have received that information from the county to render legal services to the county while he was a county attorney. And then he would have to use that information or misuse it for a purpose, a different purpose, a purpose that it was not intended for. He would, to go out and make a personal profit as a result of the misuse of that information. Is that?
I agree that that's the only interpretation of the statute that's reasonable.
Okay, so if and again, I'm just trying to make sure I understand clearly your argument. So I take it here, what you would say is Mr. Starr may have received confidential information as the county attorney, as you would expect most attorneys to have done. But that information has not been disclosed by him to third parties outside the attorney-client relationship.
Right.
It's not been misused to do something other than provide legal services to the county. To the extent that that confidential information has been used, it's been used for the very purpose for which it was conveyed to him in the first place.
That's correct.
And that if there is in fact a misuse or improper disclosure of this attorney-client information that Mr. Starr has received, obviously that might be the subject of a different regulatory body, but not the Independent Ethics Commission.
Agreed.
That would be the province of the Attorney Regulatory Board if there had been any something like that. Is that fair capsulization of your argument?
It is, Mr. Chair.
Okay. So let me move to the third statute that I think we were focused on, and that is the 2418, Section 105. I think we've been calling it the revolving door statute. Let me ask you to comment on this, Mr. Gruskin, and then Mr. Giel, I'll ask you to comment on it as well, because I think we're getting closer to the issues that concern you, Mr. Giel. Let me ask this question. In looking at 2418-105-3, there's kind of two halves of this paragraph. The top half says that an employee shall not within 6 months after termination of his employment take direct advantage unavailable to others of matters with which he was directly involved during his term of employment. Do you see that, Mr. Gruskin?
I do.
And then then the next sentence says that these matters, presumably referring to the kinds of matters that are discussed in the first part of this paragraph, says these matters include rules other than rules of general application. So presumably it would be okay to accept employment that takes advantage of or uses rules of general applicability, the kinds of rules that are generally known to everyone. Says these matters include rules other than rules of general application, which he actively helped to formulate, and applications, claims, or contested cases in the consideration of which he was an active participant. So let me ask for your view on that. When the statute talks about an application or a claim or a contested case, presumably it would be your position that if Mr. Starr left the county as county attorney and then went to work for somebody who had an application pending while he had been there, that would probably be inappropriate.
Correct.
That'd be switching sides. That would be using information that he received from the county for the benefit of another party, and you're not contending that would be okay.
Correct.
Okay. Same thing true with a claim or contested case. If Mr. Starr had received confidential information from the county in order to help them defend against a contested case or defend against a claim, you would not contend that it would be okay for him then to leave the county, go to work for the county's adversary, and reveal all this confidential information to the adversary.
And the answer is yes. I assume that revelation is what is anticipated by the direct advantage, although I'm not really sure what that phrase means. But I think that your assessment is correct. bottom line, you can't switch sides and use the disclosures that have been made to you in order to further someone who was, or a party that was on the other side of your former public client.
Okay, okay. Mr. Giel, let me turn back to you for a minute. So kind of using this example that I'm working on here of an attorney, Mr. Starr, leaving the county and then using information that's confidential, that he got as confidentially as the attorney for the county, and then going out and using that to help third parties to the detriment of the county. I've not seen anything in your papers or in the information you submitted that suggests that there was anything like that happening. Is that right?
Are we talking about Colorado Revised Statute 2418-105?
Yes,
3?
yes.
So ethical principles for public officers, local government officials, and employees. A public officer, a local government official, or an employee should not, within 6 months following termination of his employment, obtain employment in which he takes direct advantage of matters that he was directly involved with. To me, I'm just a guy on the street, and it seems like a no-brainer that even Walmart, when you quit working for Walmart, you cannot reapply for 6 months. So I don't, this is all about ethics, and the statute's real clear. It says the employee should not do this, should not take employment. So, you guys are the lawyers. You guys can dance around the words.
Well, sometimes it might seem like that. I don't disagree with you, but I think what we're trying to do here today is understand what the legislature intended with each of these prohibitions and what the harm was that they were trying to address. And so I'd ask you to be patient with us and try to understand what it is that we're doing here.
Mr. Chairman.
Commissioner Smith?
Thank you, Mr. Chairman. Mr. Giel, to help you along with this, let me do as I think the chair has tried to do before. And the operative part of this that I think that the commission is asking you is to take direct advantage of. Are there facts which you want to bring in front of this commission that meet the component of fulfill that statute, take direct advantage of? Mr. Chair, you've got your language.
To me, this looks like a fifth grader would figure this out. The county handed all of their legal services to it's Rose Walker Starr with this contract so that he could financially take advantage of everything that he does for the county.
And I think
I don't know, what part of that, it seems like a fifth grader could figure that out.
Mr. Giel, let me ask you a question, though. Let me ask you a question to try and put it in perspective. While Mr. Starr was employed by the county as the county attorney, they paid him a salary, didn't they? And
he was an employee, yeah.
And he received a direct financial benefit from the county to provide these legal services, didn't he?
Yes.
And as an employee of the county, he had duties of loyalty and fiduciary duties to the county to represent their interests in good faith. Is that right?
Yes.
And as an outside attorney, he'll be paid again for his services, for his legal advice. He'll have the very same, in fact, arguably more severe duties of honesty, candor, good faith that he owes to the county as an outside attorney, won't he?
All right. But that's my whole point, is we're just going to skip the whole first part of this, though, that says this is all about ethics and that the employee shouldn't take this job in 6 months. Okay. Yeah, I hear you.
Well, I think what Commissioner Smith was asking and wanting to give you an opportunity to comment on was the statute doesn't simply say that no government employee should be employed for 6 months. It says that you shouldn't be employed in an employment in which you will take direct advantage, unavailable to others, of matters with which he was directly involved. And so what we're trying to understand is where, if at all, Mr. Starr is obtaining personal, benefits from his change in capacity from an in-house lawyer to an outside lawyer. The examples that the statute gives, and just to finish the thought, let me just
all
finish.
matters he was involved with, not just certain ones. Everything that he was involved with.
Well,
Any matters at all, he was profiting off of them after that.
But let me, that's why I directed you to the last sentence of that statute, where it describes what kinds of matters the statute is talking about. And it says, these matters, referring to the matters that he's not supposed to take direct advantage of, these matters include, and then there's a list, applications. We haven't seen any evidence that he's out working on the other side of an application. Claims, contested cases, things that he was working on for the county when he was in-house, and now he's working against the county outside. So if those are the kinds of matters that the statute is talking about.
If you're going to focus just on that, not the whole thing, then no, I don't have any evidence of that.
Okay. All right, and we're not done yet. There's still another statute that we have to work through here, and that's the one that I want to step to next, which is 24-18-109, which is the statute that says, well, actually, there's two more statutes we need to talk about. The first one is 24-18-109, the economic benefit one. And this is the statute that says that a local government official shall not perform an official act directly and substantially affecting its economic benefit, a business or other undertaking, in which he has a substantial financial interest. So the way I understand the facts that were found by our investigation and that have been, I think, pretty much agreed to by both sides, it breaks down like this. Mr. Starr did not perform any official act with respect to his retention because he didn't decide to hire himself. He told the county he was leaving, and then it was up to the county to decide whether to hire him. So any official action that was taken here would have been taken by the other respondents, the commissioners. So far as Mr. Starr is concerned, there's no official act. And then when we turn our focus to the other respondents, the commissioners who approved the retention of Mr. Starr's new firm, they don't have any financial interest in the contract, any personal financial interest, because they're not associated with the Rose firm. They're not getting any of the money that's being paid for these legal services. They're just making decisions on behalf of the county. So we have an official act performed by some of the respondents, but not by Mr. Starr. Mr. Starr certainly has a financial interest in the contract, which is presumably why he disclosed it and didn't try and negotiate it on behalf of the county. But we don't have any financial interest on the part of the respondents. Do I have all that right? Mr. Gruskin first?
You do, Mr. Chair.
Mr. Giel, do I have all that right?
My first comment is it's real interesting that Gruskin was masterful in arguing this thing backwards, absolutely backwards from the way I presented it. And it's very interesting. So, I guess on the surface I have to concur with that, but I guess, we listened for 33 minutes to Mr. Gruskin present what I could have read my whole presentation in less time than that, and I would have put it together in a different order so that you can actually see right from the get-go how this was how this whole thing played out. So I'll go along and answer your questions for the moment, and I would concur with what you're presenting at the moment.
Okay. And, all right, and I appreciate that. And Mr. Gruskin, you can tell, I mean, as we go through these, I'm not addressing some of your technical arguments, and I'm doing that on purpose because some of them are very broad, and I'm not sure that the commission, will want to make rulings that, a fiduciary duty can only apply to a trustee of property, or the state procurement code can't ever apply to a county official. Those are kind of broad statements, and if we don't have to decide those, I'm not sure we want to, at least from my own personal standpoint. So the next statute that is called into question here is 2418 2011, former employee contracts. And this one is a little different than the one we looked at before, we call the revolving door statute, or it's called the revolving door statute. I'm not sure that that's a very good label for it, but this one's a little different. So this one, 2418-201, says that a former employee may not, within 6 months following the termination of his employment. Now I need some help reading, okay? And I really am asking for your views of this. It says contract or be employed by an employer. So let's just stop there. I can't make any sense out of the words because I don't know what contract by an employer means. It doesn't seem. So I'm reading this to be that a former employee may make contract, and then I'm skipping to where it says with a state agency or any local government. So it says, so I'm reading it as a former employee may not within 6 months following termination of his employment contract with a state agency or any local government involving matters with which he was directly involved during his employment. That would be one prohibition. And the other prohibition would be a former employee may not, within 6 months following the termination of his employment, be employed by an employer who contracts with a state agency or local government involving matters with which he was directly involved. Does anyone quarrel with that reading?
I think that.
Yes, because you've changed the words in the statute. It says that you shall not may not. Shall not is an absolute.
Okay, I stand corrected. Shall not.
And then
Mr.
let's
Chairman.
go ahead and let's jump to the investigation report, page 77, the Archuleta County procurement policy.
I haven't gotten to the procurement policy yet. I'm going to get there.
All right, well, it's the same interest in contracts.
Mr. Chairman, just so you know, the statutes have been uploaded to your machines. The wording in question is not shall not. The wording in question is may not.
Okay, a former employee. The way the statute reads, what we're looking at, Mr. Geel says a former employee may not. I guess I'm not differentiating may not and shall not. It all seems to be the same to me. So that's the way I don't think there's a material dispute about that part of the statute. So let me.
I wonder where where that came from as far as your version of the wording.
Well,
Shall not is an absolute. May not isn't.
Well, it's a good point. Let me go back to this and break it out a little bit. So 2418-201 has, again, two halves to it, just like the earlier statute did. The first half says that public employees shall not be interested in any contract made by them in their official capacity. So in this example, this case, I think the same thing we said a minute ago applies. Mr. Starr did not make this contract on behalf of the county. He didn't make this contract in his official capacity. When he was negotiating this contract, he had clearly disclosed to the county that he was leaving the county, that he was going to a private law firm, and any discussions he would have had with the county would have been in his capacity as a private contractor, soon-to-be ex-employee, leaving the county. So I'm setting aside the first half of this statute as being inapplicable to Mr. Starr. The second part of it, however, says a former employee may not, within 6 months, be employed by a local government or within 6 months following the termination. It says a former employee may not, within 6 months following the termination of his employment, be employed with or contract with a state agency involving matters with which he was directly involved during his employment. So this, of all the provisions that we are dealing with in the brief, and all the issues that we have to deal with, I think is the one that requires the most sort of careful thought. Because as you can, I mean, if you just read the text of the statute, we really need to try and understand what the intent and purpose of this prohibition is. Would it really prohibit, for example, an RTD bus driver who's an RTD employee leaving the employ of RTD and going to work for one of the private contractors that contracts to operate buses for RTD and continuing his or her work as an RTD bus driver? Would this amendment really, and this statute really be intended to prevent that? Or is it really trying to get at something different? And I guess again, I'm going to.
Running a response to me?
Sure. How about that, Mr. Gill? What would you respond to that?
Okay. So let's stay in the real world and not RTD world. In the real world, Mr. Starr was on the payroll. He was on the clock the whole time this was going on. Okay? So in that first paragraph where it says, specifically, employees shall not be interested in any contract made by them in their official capacity. Was he on the clock while this contract was being put together? What's the answer? Yes.
I think we're assuming that the answer was yes, that there were a period of a few days before Mr. Starr left his employment as county attorney.
A full 3 weeks. A full
All right,
3 weeks.
3 weeks in which Mr. Henderson,
Yep, and he had that contract in his pocket already.
in which Mr. Henderson was negotiating the contract on behalf of the county.
That's not true because right to my face, Mr. Henderson said nobody negotiated that contract. That's what Mr. Henderson told me at a BOCC meeting. And I tried to question him about that, and he got all frustrated, refused to talk to me, and walked off. And so I guess there's a comment in the investigation where Mr. Wadley makes a comment that Mr. Gill doesn't understand how the government works, and so that must be what he's talking about. You don't negotiate contracts, because that's what Bentley Henderson told me to my face, and here we are today.
Mr. Gruskin, you want to comment? You want to comment on that? I know I saw somewhere in the papers, and I thought it was an affidavit submitted that to the effect that Mr. Henderson was appointed as the person for the county to handle the discussions with Mr. Starr about the contract. Do I have that wrong?
You do not, Mr. Chair. Stipulated fact 12 is that it is the responsibility of the county administrator to address issues such as sole sourcing and negotiating contracts and making recommendations to the BOCC. And stipulated fact 7 states that, in fact, Mr. Henderson did negotiate the terms on behalf of the county commissioners.
All right, well, he lied one time or the other. Let's move on.
So, Mr. Gruskin, let me turn back to you for a minute. I think your comment to us was that, first first of all, some of our prior rulings said that we would defer to a public entity to determine whether or not a conflict existed between the new employment and the old employment. I think we're aware of those opinions, and I think we do generally look to the agency itself to tell us whether or not it has a concern about this, because obviously, if the agency has a concern, then that changes the color of it a little bit. I think it's a true statement that we don't automatically defer, we don't defer conclusively, but we take it from the papers that have been submitted that the agency does not believe that there's a conflict between Mr. Starr's former employment and his new employment. I think we can take notice of the fact that there's a whole separate disciplinary board out there that presumably will make sure that Mr. Starr's engagement for the county as an outside attorney will be performed with loyalty and for the county, towards the county. And actually, as an aside there, let me ask a question about this. I saw some kind of some correspondence in the papers with the attorney disciplinary board. I don't know where it came from. And I did see the fee agreement that talked about an unearned, basically a flat fee retainer that would be earned on day one, and that it would be retained even if no matter how many hours were worked. And then I saw a revised engagement letter that seemed to get rid of the minimum retainer. Can you shed any light on for us on that, as to what that sequence of events was?
Sure. The documents establish that the letter from attorney regulation has nothing to do with this claim. Absolutely zero. It's a letter dated 2013, and if Mr. Starr were to testify, again, I'd make an offer of proof that he'll be able to say that as recently as yesterday, he contacted the Attorney Regulation Council, who stated, and we can provide a document to that fact, that there's absolutely no disciplinary action either pending or taken against Mr. Starr. The issue about the two contracts was that the original October contract was drafted. It was the subject of discussion at a public meeting of the commissioners. It was approved. Subsequent to that, the issue of whether or not the retainer arrangement was consistent with the Code of Professional Responsibility was brought to Mr. Starr's attention. He recrafted the agreement with the county to reflect concerns about that, so that he would only be billing on an hourly basis with a retainer that could be replenished based upon hours that were billed during a particular month. And that is the agreement under which the parties have operated.
Okay, and I don't mean to suggest that either agreement would be a violation of the rules of professional conduct. I think that would be a matter for the disciplinary board. Certainly, if you've practiced law as long as you have, I suspect, and I have, you remember the days of flat fee retainers, and particularly in the case of a county or a state engagement where you are essentially conflicted out from representing everybody who might have an adverse interest to the county, whether or not that would be an appropriate engagement or not. But I don't think that's a decision we need to reach. And Mr. Giel, for your benefit, just so you appreciate what we're talking about here, our mandate has limits. We can look at government ethics and government ethics. And when it comes to legal ethics, there's a whole separate board that looks at legal ethics, and so we don't get to do that. When it comes to judicial ethics, there's a whole separate board that looks at judicial ethics. We don't get to do that. And when it comes to the wisdom of decisions, county decisions, we don't get to do that either. So what we're doing here this morning in part is parsing through this case to see what, if anything, here might implicate the limited scope of what it is that we are assigned to do. So let me...
Are we going to get back to the conflict of interest as far as the ethics on that, where we were at before?
Okay, so you've used the term conflict of interest a couple of times. So let's assume that I've got the facts all right here. And
well, I'll just guide you to the investigation report, page 77, the Archuleta County Procurement Policy. It's part 3.12, conflict of interest. It states, Archuleta County shall not contract for goods or services with an employee, elected official, or administrative officer. There's that pesky shall not again. It's an absolute term. Now, the interesting thing says that exceptions, and this is where Gruskin was trying to go. Basically, it says, due to the nature of small rural community of Archuleta County, it may not at all times be feasible to exclude local vendors from doing county business as described hereunder. In these cases, the county attorney, Todd Starr, shall make the determination of whether there's a conflict of interest. That's interesting. So the guy they're contracting with is going to be the one that determines whether there's a conflict of interest or not. Since Commissioner Lucero actually signed their procurement policy when it was brought into effect, maybe he can explain that to us, because Lucero should have been guiding the whole county commission through how to do this procurement policy instead of ignoring it.
Well, let me ask a question, and let me ask a question about this. So, I understand what the procurement policy says, and I suppose, again, using a different example, I suppose if Mr. Starr, while he was county attorney, had started some kind of separate business, doing legal notice publications. He owned the newspaper, and the county contracted with his newspaper to do all of its legal notices, so that there was a contract between the county and a current employee of the county. I think I'd probably view it differently, but can you tell us why you think this procurement code prohibition, just on its terms, by its face, would prohibit the county from contracting with a former employee? In this case, we have Mr. Starr.
Wait a minute. You're doing that lawyer thing again, because you're changing the words of what this actually says. It actually says Archuleta County shall not contract for goods or services with an employee. Todd Starr was an employee, and they made a contract with him. He had the contract in his pocket for 3 weeks before he quit.
All right, so your claim is that because he stayed on the job for 3 weeks after he had disclosed that he was leaving.
Wait a minute. What difference does it make how long he stayed? It says you won't contract with an employee, and he was on the clock. He was on the clock while they were doing it.
Do you have any reason to believe that the county paid him his ordinary salary for those 3 weeks, and in addition to that, paid him anything under this contract during that time?
We're talking about conflict of interest in the procurement policy. This is procurement. This has to do with establishing the contract to begin with. He was an employee. They contracted directly with an employee that says you shall not do this. That's an absolute violation. If you roll right through, if you just blew through a stop sign, would a cop just say, "Oh, it's okay. Maybe you'll stop at the next one"? No. It says shall not contract for goods or services with an employee. Come on. Clifford Lucero signed that document when it came into effect back in 2009. And he was there. He was involved with this.
Okay, I think we understand your argument. One point I would make is that one of the things the commission has been very disciplined about is we are not the super procurement agency for state and local agencies. So there could be 1,000 different ways to violate a state or county procurement code that would not create an ethical issue. Might be, an example, county only got 2 bidders, not 3 bidders. Is that an ethical
Didn't get
problem? Just, excuse me, sir, please don't interrupt. We're trying to explain what the commission's past rulings have been. And so, for example, a county or a state agency might violate the procurement code by not seeking sufficient outside bids or not awarding the contract to the lowest bidder. We would normally not treat that as an ethical issue unless the violation of the procurement code implicated some ethical rule like self-dealing or a conflict of interest. So if the argument is that the county commissioners hired a lawyer that was too expensive, that wouldn't implicate our jurisdiction. We wouldn't do anything about it. If the argument was the county commissioner should have hired a $75 an hour lawyer instead of a $300 an hour lawyer, we would not intervene in that because it's not our job to make decisions for the county. We don't get elected. Nobody elected us to do that. That's up to the county commissioners, and if they've made a bad decision, then the voters will take care of that and not us. So our sole task here is to determine whether or not there was a violation of a procurement code that implicates some kind of an ethical issue. Okay? All right, I think I've pretty much asked all my questions, and so...
Mr. Chair, could I follow up with one point?
Yes, sir,
on
Mr.
that?
Briscoe.
I apologize. Under the Archuleta County procurement policy, Section 3.12, the conflict of interest provisions, I probably didn't make it clear, but to the extent that we're picking apart this provision, let's do it. So there are really 3 prohibitions under the conflict of interest policy. Number 1, the county can't contract for services with an employee or an official. They didn't contract with Mr. Starr. They contracted with a law firm. The second prohibition, or a company which is owned in whole or in part by an employee. Mr. Starr is an equity owner of the law firm, and he certainly wasn't while he was a county employee. And the third prohibition is, or a company in which an employee or other officer has a financial interest. Well, financial interest is specifically defined in the procurement policy of Archuleta County. And that says financial interest means any interest in the business by means of a loan or other evidence of indebtedness in excess of said business's outstanding indebtedness. So it's not any financial interest. It's some sort of loan, some sort of debt. Conflict of interest policy doesn't apply here. The contract wasn't with an employee, it was with a company. It wasn't a company in which he had an equity interest, and it wasn't a company that had any sort of debt relationship with the county.
Well, look, I understand your argument, and I'm not sure I'm persuaded by it, just speaking to myself personally. And the reason for that is because I think it's a little bit of a technical argument to say that when Mr. Starr was opening an office for a law firm in Archuleta County to represent clients, that because he wasn't an owner, that somehow resolves the issue. I'm not sure we have to reach that point, I guess is what I'm saying. I have a different and much more fundamental issue here, and that is that I understand the argument that Mr. Giel is making, that Mr. Starr stayed on the job for 3 weeks after the contract was signed, but this is a contract for the rendition of professional services. And by definition, these services under this contract could not have been rendered until after he left his employment at the county and began work for this private law firm. And until he left his employment as the county attorney, he continued to work for the county. He was paid by the county. He got a salary from the county. And there was no work done or monies paid under this contract until he became a former employee. I cannot get my head around, and I cannot give the reading that Mr. Giel wants to give to this procurement policy that would in fact add a word to it. The policy does not say that it is an ethical violation or a conflict of interest for the county to contract with a former employee. And in the way I view the facts here, Mr. Starr worked for the county. He was a loyal county employee while he worked there. He left the county. He went to a separate law firm, and he's been a loyal attorney for the county since then. And so they paid him as an employee when he was an employee. They're paying him as a lawyer now that he's a lawyer. And I don't see how that implicates the procurement policy, but that's just me. So,
You added a word in there that's not in the policy. You said a former employee. It says Archuleta County shall not contract for goods or services with an employee.
I think we're saying the same thing, Mr.
It
Gill.
doesn't say former, it says with an employee. Todd Starr was an employee when they contracted with him. Period.
Well, that's where we
Let's say
disagree. That's where
former.
we disagree.
It doesn't say, that's the part, it's very, it's
All right.
interesting how something that is plain English is not comprehended.
Okay, so now I've finished my questions, so now I'm going to open it up to the other commissioners. I'm sure they have some questions of Mr. Starr and Mr. Gill.
I'd like to address that sole source before we move on.
Well, we'll come back to you in just a minute. I want to give the commissioners a chance to get the questions that are important to them answered. Okay, Mr. Gill, so just hold on for this for a minute.
All right.
Maybe I presumed wrongly. I'm giving everybody a chance and actually, if you want to take a very short recess to gather your thoughts, we can do that. We've been at it now for almost 2 hours, so do you want to, what's the pleasure of the commission? Okay, Mr. Gill, we're going to take a 10-minute recess, and we'll be back in 10 minutes.
All right.
meeting of the Independent Ethics Commission on August 10th. We took our short recess, and we're ready to get going again. Commissioners. Commissioner Bacon.
Thank you, Mr. Chair, and I have been intrigued by the parsing of the chairman on all of these allegations and the responses. Not being an attorney, this is all unfamiliar territory, and I'm in awe of the ability of people to deal with all this. And as I listen to all of this, one area may have some concern for me, and this is the one dealing with the last one that we have just discussed, which was the employee being...
I can't hear. You got to speak to the microphone.
Oh, I'm sorry, Mr. Giel. And this is for you as well as anybody else. And so I'm trying to figure out whether or not this employee was using an unfair advantage and getting a contract while he was an employee. And so I look back to the facts that were not contested. And so Mr. Starr resigned on September 22nd, and I assume from my old school board experience that in that he said it was going to be effective on October 21st. And so in my old school board experience, as a member, I would have said, oh, golly gee whiz, what are we going to do now? We no longer have a county attorney, and this individual does have some information and a great number of skills that has served us well. And then we may have learned, this is only conjecture, that he was intending to go into private practice. And perhaps in a conversation saying, I could provide some services for you, but I no longer am the county attorney. And so in the process, the county commissioners have their county administrator try to form a contract, an agreement with a firm that he may become a part of in order to continue those services, with the possibility as a savings for the county in the money. And so putting myself in a position of a county commissioner, it seems like making the best out of what potentially could be a very disastrous situation in not having somebody who is effective and knowledgeable in representing the county as an attorney. And so I think that probably for the county commissioners, they made the best decision they possibly could in order to provide the services that they needed, as well as being good stewards of the taxpayer money. And so the last allegation could be, a suggestion is there that he was complicit in all of this, but he resigned effective a certain date. The county commissioners had an issue with which they had to deal, and a solution was presented to them, and they opted for that solution, and it seems like a good solution for Archuleta County. And so I can find no fault there with the individual who has helped the county with the problem that they may have had without any kind of legal representation.
Do you want to go first?
I can't hear anything you're saying.
Commissioner Jones is going to go next.
I'd like to just address what the commissioner just said.
No, sir, we're going to let the commissioners, we're going to go down the table, and then we'll give everybody a chance at the end to say their sort of last piece.
Can I have you clarify what you refer to as the cost savings aspect?
Yes.
So you indicate at one point that Mr. Starr's salary was $109, but that you had budgeted $250. Is that right?
Correct. Using benefits and overhead and the total cost of the county attorney.
So were the total cost of Mr. Starr $250, or is that just what was budgeted for the position?
It was $230,000. It's in both the facts and the affidavits, exhibits U and V.
Yeah, I'm pulling these from the facts. I just have questions about them.
Okay.
So my question again, his salary was $109, but the total expense for his position was how much?
Just for him.
Correct.
correct? I believe the total expense for him was, I would have to take a look at the papers, if you don't mind.
Is anybody talking? I can't hear anything.
Could I confer for one moment,
Yeah,
just so
should I
that
ask if you can hear me?
Answer it.
Can you hear me?
I can hear you now. Everybody has to speak right to a microphone to be heard.
Did you hear my question?
You were questioning about the difference between the budgeted amount for legal services by the county and what STAR's payroll was supposed to be.
That's correct.
So the specific expense that is limited to Mr. Starr would be, I'm informed, about $159,000.
Okay. So when you say the position was budgeted, I have in my notes 250, but maybe I rounded. You said 230. You paid him 159, and you already had money on the table that you weren't spending on the position. Is that correct?
Well, there were other expenses, paralegal expense, that kind of thing. So that was the whole county attorney line budget, not just Mr. Starr.
Okay. So he had his salary that's grossed up to 159, and was the remaining budget for the position utilized, or was it just budgeted? Is what I can't tell.
If I could confer?
Sure.
I don't hear anybody talking.
Mr. Giel, no one's talking. We're going to make sure we speak to the microphone, and this is one of the reasons that we invited you to attend the hearing, so that we wouldn't have technological problems, okay? So are you still watching this on the live feed? Are you still watching on the feed?
It's delayed.
Mr. Chairman, there's a delay.
I'm listening on the phone and watching the live feed, yeah.
Okay, all right. Just bear with us for a minute. The respondents are conferring, they're looking at some papers to try and answer Commissioner Jones' question.
I would like to put this in that I forwarded a Cora request for Mr. Starr's payroll 6 months prior to him holding a dual position as attorney and county administrator. During the time he was holding both positions and 6 months afterwards, that was a document I wasn't able to get in by the document deadline, but I went ahead and forwarded it so that you can look at it. That'll give you an idea of how you come up with the difference between budget, a payroll, and the total cost, because he would bill for all sorts of other things.
Mr. Chairman, I did receive the document to which Mr. Giel is referring. That document does not appear in your packet because it came out after the deadline, and as I recall, it was not copied to Mr. Gruskin.
That's not true. I sent it to him.
I'm sorry, I was conferring. What documents are there?
Let's just kind of take things one step at a time. I think Commissioner Jones' question is directed at how much money was actually spent on Mr. Starr when he was with the county versus how much money is being spent on Mr. Starr since he left.
I hadn't gotten there. My question was how much was budgeted and how much was spent of what was budgeted?
I am informed that of the $230,000 budgeted amount, approximately $200,000 was spent on the county attorney line item, which deals with salary, overhead, administrative assistance, and benefits.
And there is no overhead, no administrative assistant, and no benefit in the current arrangement, correct? No benefits? I mean, no, there's no assistance for the county?
I am also informed that that assistant works for the county commissioners, so that's been absorbed otherwise. But no, there's no independent salary arrangement, there's no independent benefit arrangement, there's no independent disbursements for overhead in his law firm, other than, I'm sure, ordinary expenses that would be billed, like travel or copying or.
Okay, all right, that is helpful. So how is it that he can do the same job at only 20 hours a week that he could do full-time? And have that be satisfactory for the
Well,
position?
If you take a look at Exhibit F and read the entire investigation, one of the,
I have read it.
okay, one of the downsides.
Still have a question.
No, it's a substantive question. One of the downsides from the commissioner's point of view was that they didn't have someone who they could just pop in to and bounce any question that was on their mind off of. And so they were.
Why wouldn't that be Mr. Starr?
Well, the point was that they were going to have to be a lot more targeted in making requests for legal advice because it was going to be on an hourly basis. But nonetheless, the substantive, the substance of what he does, the meat of what he did for them, he could do in the 20 or so hours that would be anticipated under the contract, or not. There have been months where it hasn't been a 20-hour exercise, but overall, it still has reflected a savings to the county.
Okay, so can you explain again how a full-time job and a part-time job end up being, how is it sufficient that he can do his job in 20 hours instead of 40? And I know you just told me something about they could go in his office or not, but that doesn't really help me. Because my concern is you have cost savings, but you have half the help and an attorney. So that's why I'm asking you if you could explain that to me.
Well, number one, I would sense that Mr. Starr is a lot more efficient when he's on the clock.
When he's on the what?
When he's on the clock as a contract employee. And his history had been, as I'm sure you know, as fulfilling a number of jobs at the county. He was county administrator for a period of time, for instance. So a number of the types of things that would be requested of him in terms of advice or counsel weren't strictly legal counsel, they were more operational. And it may just have been that the county doesn't really need a full-time county attorney. I mean, I think that it is true that the county's resources are being more efficiently allocated now that they're not having to pay for a full-time county attorney and his or her benefits and the overhead associated with that position.
Okay, so I was just trying to understand the apples-to-apples cost savings of the changing from to the contract. Because if you, okay.
Maybe I can put it this way. The county doesn't get the same amount of legal advice that it used to. But the county is targeted enough in seeking legal advice that it gets all the legal advice it needs. And it's also true that whereas employees or division heads would have popped their head in and spoken with Mr. Starr, they now go to the county administrator and seek advice, operational advice and other advice from the county administrator.
Hello? Anybody there?
I haven't asked a question yet, so we're here. I'm looking at my notes. And how is it that you know that there was no other qualified person in the county when you didn't post the position?
The commissioners, and specifically Commissioner Whiting, who's the chair of the commission, are in a position in a county of 12,000 people to know about the available legal talent. Mr. Starr is as well. There is, frankly, a current instance where the city of Pagosa Springs is seeking a city attorney, and they cannot find anybody within Pagosa Springs or Archuleta County who has the requisite skills as a public attorney to cover the array of issues that position addresses. So it is.
How are they resolving that? Curious.
Mr. Starr informs me that they are talking to Mr. Starr, an attorney in Durango, and attorneys in Denver.
And I have a question for Mr. Gill. Can you hear me?
I can now.
Okay, so I have a question about the 2418-105, the ethical principles for public officers, local government officials, and employees. Are you familiar with that? We've talked about that a lot.
Wait a minute, we're talking about, what statute was that?
24-18-105.
Hold on, I'm scrolling down because in my presentation, I took every one of the statutes that Dino put out there, and I addressed each one with the investigative report.
Okay, well then let me ask you a question about it. And it's also referenced in the response brief, Roman numeral 6.
What? Roman numeral 6.
So however you want to refer to
And
it,
whose response?
the respondent.
Oh, I don't have that up here in front of me. What did they say?
It's fine, I was just trying to help you find it for ease of reference. So if you can let me know when you...
I'm not looking at anything that they put up.
Okay, can you look at your notes on 24-18-105, which we've been referring to today as
Section 3.
as the revolving
I have it right in front of me.
door? Okay, so can you tell me your thoughts on what the commission's supposed to do with the language that says ethical principles for public officers, local government officials, and employees? Number one, the principles in this section are intended as guides to conduct and do not constitute violations as such of the public trust of office or employment in state or local government. If it's intended to be a guide of conduct and does not constitute a violation, what is it that you would be asking of the commission, or is that your understanding?
I'm going to refer to the very beginning of my presentation here. Come on. My computer's being very slow. Moment. Because I kind of addressed the concept basically in the very first paragraph of my presentation.
All right, if you can tell me right now, that would be helpful.
Well, all right, so the oath given by any government employee prior to entering an office of profit is one that is sacred. It creates a fiduciary trust that clothes them with civil immunity, as long as they do not dishonor their given oath and break that trust. Once that trust is broken, the government employee is acting on their own. Effectively, they've chosen to become outlaws.
Okay.
So, what does it mean that you shouldn't do this in 6 months? If we start at the top with even Walmart will not let you reapply for at least 6 months when you quit. Why is it that he's decided? I think I can answer a bunch of things real quick.
Okay, what I'm asking you very specifically, sir, is about 24-18-105. We've explained today that the commission does have parameters, and
Right, and so it says in 6 months you shouldn't do this, and they did it. I mean, there's at least 3 different things where it says within 6 months you shouldn't do this, and it was. I mean, they didn't even let the clock run out. Matter of fact, if you read the judge's editorial, Todd Starr originally agreed that he would give a 60-day notice. Why did he give a 30-day notice? He's the one that created this panic condition.
okay, and that's your final answer to my question about the commission being...
6 months, you shouldn't do this. You shouldn't put
Okay.
yourself in that position. He's the
Okay.
one that put himself in that position.
Okay, we are nonetheless bound by the statute, sir, and so I'm trying to understand how we can help within the bounds of 24-18-105, but we can move on. Do you have 24-18-201?
I do. What's your question? Hello?
Hi, I'm taking a look at my computer, if you give me a second.
Oh, okay. All right. I understand it's technology.
So this is the procurement code, and my specific question is about the language that actually turned to 24-101-105. A 24-101-105. Oh, you need a second volume. Okay. Yes.
3 specifically?
24-101-105, 1A.
Oh, 101. All right. I've got 24-18-105.
So I can read it to you, and it's talking about application of this code. It says, "This code shall apply to all publicly funded contracts entered into by all governmental bodies of the executive branch of this state." And my question is, we're not dealing with the executive branch here, and how is it that you are seeing that this applies?
Is Archuleta County a subdivision of the state? Is the corporation County of Archuleta a subdivision of the state of Colorado?
It's a county.
Is it a subdivision of the state? Is it an artificial entity?
I'm not sure how you're using, all political subdivisions and local public agency of the state. Oh, sorry.
It's an artificial entity. It's a corporation. It has to operate within everything the artificial entity state of Colorado, because we're not talking about the dirt or the people. We're talking about that corporation.
Yeah.
Mr. Gill, let me ask you a question here to follow up on Commissioner Jones. So looking at the statute that she's referring to, there's two sections. The first one says that the state code applies to publicly funded contracts entered into by the executive branch of the state. And then paragraph 2 says that political subdivisions and local public agencies are authorized to adopt all or any part of this code and its accompanying rules. I don't know if that helps you, but I guess the question is, we've seen the Archuleta County Procurement Code. I'm not aware of any general Archuleta County ordinance adopting the state procurement code. Is there one? Mr. Gruskin is nodding his head no. The commissioners are saying no.
A rational look at the whole thing would be that when the Archuleta procurement policy was set up, they tried to frame it within the same framework. I thought they did a good job.
Okay, but in terms of us getting around the limitations of 24-101-105, and you responded that we should look at the, basically F2, or 7.2, that all political subdivisions and local public agencies are authorized to adopt all or any or part of this code, and it's been indicated here today that that has not happened, that they have not adopted the code in Archuleta County. So again, how are you seeing that the commission has authority to make findings of fall under 24-1-105?
Does the Archuleta County Procurement Code, is there any part of it that is in opposition to that code?
Is there any opposition to the code in the procurement code?
Yeah.
There's certainly, Madam Commissioner, there's certainly provisions that are very different, not as comprehensive, don't require approval by the executive director, don't require approval by the head of a purchasing agency as defined by statute. So it is.
Let's move on to the sole source and we'll address what he just said.
I'm sorry, it's my question. Can you please allow him to continue?
Thank you. There are provisions that deal with procurement, but they don't happen under the state procurement code. And so there are some parallels, but there's no adoption of the code. It's clearly been tailored for purposes of the procurement needs of Archuleta County rather than trying to fit in with the general framework of the state of Colorado.
I believe it's Article 5, Section 25 of the Colorado Constitution that basically says that the people in the county can either accept whatever the general legislature puts out, or they can refuse all of it at the ballot box, or pick and choose what parts of it they want to make part of the county.
And then my last question so far is for Mr. Starr. So in terms of when you started the law firm, and so you don't have any equity interest in it, but your name is in the name. And when did it begin to exist?
Is anybody speaking?
Mr. Starr, it's okay if you want to address this directly. We're not high on formality here, and so if you'd like to address that, that's fine.
Thank you, Mr. Chairman. Ma'am, the law firm Rose Walker is a Dallas-based law firm that was started by Marty Rose and Hal Walker. I'll get in trouble for not knowing this, but I think it was 1990, give or take a couple of years. That law firm had an office in Durango, Colorado, that was run by a lawyer named Duke Eggleston for, I think, a year, and then Mr. Eggleston left, and the law firm was kind of not sure what to do with its Colorado presence. And then I came along. The reason that my name is on the door is because my reputation in Archuleta County and Southwest Colorado drives business.
So did the firm exist in Archuleta County?
Technically, the firm existed. It had, I think, Marty Rose, who is the driving force behind the law firm, is also licensed to practice in Colorado. He owns a home in Pagosa Springs. He had maybe one or two clients that were partners of his. So yes, the firm existed, but the firm was not operating. They were not actively seeking clients.
And they didn't live in the state?
He has a home there, but he is a Texas resident. There was no member of the firm in Colorado until after Mr. Eggleston left, until I became a member of the firm.
And when was that?
It would have been, what was it, October 22nd? Mr. Rose and I began discussing, it would have been, I think, May or June prior to that.
And does the firm have other business in Archuleta County besides the contract with the county?
Yes, since the firm had, through Mr. Rose, because he owns some significant property there, the firm had an interest in a domestic case, a large domestic case involving a Dallas doctor that they were hiring local counsel for. And when I came on, I replaced that local counsel because obviously I was part of the firm, so we no longer needed that. But until I became a part of the firm, it was not actively engaged in generating business in Colorado.
And do you have other significant business other than the county contract currently?
Certainly, the county is my largest and most important client, but yes, I have other significant business, which I believe in 2017 will create substantially more revenue than the county.
Yeah.
And on August 1st of this year, we opened a Denver office.
Nothing further for me at this time.
Commissioner Smith?
Thank you, Mr. Chairman. Ladies and gentlemen, I appreciate your patience. The whole commission does. And I know the commission has explained this to you. It may seem as though the commission is being very technical, following very exact language in the statutes, but that is what gives us guidance on the standards. And I hope you find it interesting. It's something that the commission is obligated to do. I am going to follow up where the chair was and ask both Mr. Gruskin and Mr. Giel some questions. I know one will please Mr. Giel when we get to it, but I would direct your attention to the procurement policy on page 17 on the signature authority. I do not claim to be an expert, but you all handed us that document. We looked at it. I just have some remaining questions. Mr. Gruskin, I'll start with you. Give us your understanding of the signature authority, if any, and I'm looking under section 2.1. There's both the introductory paragraph and then there is a provision called signature authority guidelines, page 17.
It's right here.
Let me preface this by referring to the Commission's order of May 2nd. Commission's order of May 2nd identified the legal grounds that are the subject of this hearing. In terms of the Archuleta County procurement policy, it specifically says, this is the signed order, that we are to deal with the ethical aspects.
I can't hear anything that's being said.
For Mr. Giel's purposes, the May 2nd order of the commission says that the Archuleta County procurement policy is relevant as to its ethical aspects. Section 1.3 of the Archuleta County policy deals with its code of ethics. So without getting into the substance of the statutory authority guidelines, this is beyond your order. I'm happy to answer your question and will.
And that's fine if that's the position you want to lay out. I just wanted some guidelines, and I'll let Mr. Giel respond, and then I'll just add a follow-up comment and move to my next question. Mr. Giel, do you have anything to add to my question concerning?
I was trying to turn to what you were, I have the investigation report in front of me. That page 17 of the procurement policy, what page is that of the investigation report?
It's not in the investigation report. I'm talking to the procurement policy. I'm just trying to finalize. It's a rather large document, trying to gain a little more understanding and see if it has any application to the questions that are in front of us. Do you have any comments?
The procurement policy
Yes.
was included in the investigation report by Dino. And in all of my presentation, I cross-reference everything that I say. I put the page of the investigation report and the page that it is in the procurement policy. So I don't have them separate.
And that's fine. I understand your answer, and I can go back to your material.
I believe it's page 56.
All right.
He believes it's page 50.
I got it. I'm getting there. I'm up to page 7.
What? I'm sorry, Dino, page 56 of what? What are you referring to?
Of the report of investigation. I believe it's page 56 of the report of investigation. If I remember the pagination correctly, that's roughly where it will be.
And are you talking about the signature?
The procurement policy is page 56.
56, it's thereabouts, Mr. Giel. I'm estimating based on subtracting pages from what I'm looking at.
Okay, well, I actually have it in front of me now. So what's the question again?
My question is, do you have any comment regarding section 2.1, and more specifically, the section there about the signature authority guidelines? I want to emphasize it says guidelines. Mr. Giel?
In my presentation, I actually did address that. I'm trying to figure out where the heck that is now. Because in the county's procurement policy, it basically says that there's a $2,000 threshold. Find it. I did address that in my presentation. We're jumping all over the place. This is confusing. All right, so I'm gonna just do this off of memory. There's a threshold of $2,000 that's over. It's actually, I believe the wording says something to the effect that it is above the procurement, whoever the person is that's dealing with it, or the elected official, and that anything that they do has to be backed up by documentation, and that documentation would also satisfy the state procurement code for the exact same thing.
Thank you. I'm moving on to my next question, and it's found on page 42 of that document. So flip on back an appropriate number. And it's the number 2 that appears on that page, and it addresses service contract. And I think Mr. Gruskin has addressed the whole service contract and how it's dealt with under the code in his brief. But Mr. Giel, do you have any questions? And Mr. Gruskin, I don't mean to cut you off, but I think you've already addressed this in your brief.
So we're talking about page 42 of the county's procurement policy?
Yes, sir. It's number 2 on that, talks about service contracts.
4.1B2.
4.1B2, but it's still on page 42, correct, Dino?
Yeah, I can only go as fast as this thing will scroll.
Okay? And like Ms. Jones, I could take a few minutes and read this out to you if you need to, Mr. Giel.
I'm almost there.
It's talking about types of contracts, and it splits out a variety, and it specifically,
Okay.
number 2 talks about service contracts.
Okay. So what's the specific question?
My specific question is, do you think this has any bearing on, I guess, the application, more specifically, ethical application of this code to the case we have in front of us?
Well, it addresses something about only the county administrator or the chair of the Board of County Commissioners has authority to sign service contract for the county if the total value exceeds $50,000. $6,000 a month times 12 months is $72,000, so that obviously exceeds that amount. How does this affect? What are the ethical implications of this? Is that
Yeah.
what you're actually asking?
That's ultimately what I'm asking. Is there any ethical application of that particular section to the contract that was issued in this case?
Well, let's take the last sentence of that particular number 2. It says the county representative must be designated for each service contract and specified within the contract. The individual will coordinate with the procurement officer to be accountable for all aspects of proper contract administration related to the service being furnished. So, because of the testimony of all 3 commissioners to Dino, they all testified that the procurement policy wasn't even addressed. They didn't even look at it.
Okay, I don't know I agree with your conclusion, but I thank you for your answer. Mr. Gruskin, we have your brief on the service. Do you want to add anything to that section?
I'd only suggest that these other provisions, I mean, this section is entitled Contracts, the subsection is dealing with contract administration. I would suggest to you that these provisions of the procurement policy deal with the effectuation or implementation of obtaining or administering contracts. It's not about the ethics. And even if it were, this particular provision, in contrast to that provision that you pointed out earlier, authorizes the chair of the county commission to sign a contract in excess of $50,000. And I just point the commission to Exhibit R that is signed by the full county commission. So it was probably in excess of what needed to be, but it was certainly signed by the chair.
And thank you for that conclusion. That's where I'm looking at. It was, in fact, the exhibit in front of us was signed by all 3 county commissioners. And my last question, I believe, on the procurement code goes to the sole source provision, which is found on page 25. And Mr. Giel, I know you've been chomping at the bit to address this matter to the commission. So again, I'm inviting you to explain to the commission how you think this particular section impacts the decision that's in front of the commission.
Okay, so let's look at what I consider the silly argument of a sole source argument put forth by Gruskin for the respondents. 24-103-201C and 24-103-205. This is really 24-103-205. The 201 talks about sole source, but there's no detail. You have to go to 24-103-205. Sole source procurement. Contract may be awarded for a supply, service, or a construction item without competition when, under rules, the executive director, the head of purchasing agency, or a designee of either officer who is in a higher ranking employment position than a procurement officer determines in writing that there is only one source for the required supply, service, or construction item. Now, so let's go to the investigation report, page 64, which is the Archuleta County Procurement Policy, page 25. Sole source. Occasionally it is necessary to purchase supplies, services, or construction items without going to bid, or that only one firm is in a better position to provide. Examples of potential sole source purchases services include state bid, engineering, or other professional or consulting services. So Todd Star would be a professional service. Items for resale, yada yada. When authorization above the department head or elected official level is required, expenses above $2,000, written justification for the sole source request shall be attached to the documentation requiring approval. So let's look at investigation report, page 3, paragraph 7. Whiting states, there was no discussion at any time of the Archuleta County procurement policy. Whiting said that hiring of Rose Walker Starr should be likened to a single source situation where only one contractor is involved. Investigation report, page 5, paragraph 3. Lucero stated, there was no discussion of the Archuleta County procurement policy in hiring Rose Walker Starr. We sole sourced, he stated. Lucero explained his understanding of sole sourcing as contract with one firm without the need for a competitive bid. Investigation report, page 6 and 7, paragraph 9. Wadley does not know if the 2009 procurement policy is currently effective or when it was last revised. He does not think that the procurement policy was discussed in depth during the rehiring discussions. So he indicates right there that there seemed to be some extensive discussions about hiring Starr. Any decision Wadley would make would have been in light of that policy, but Wadley did not get the book out. Now this is just their own testimony. So what makes this whole argument silly is that about the same time frame the BOCC hired another law firm to represent the county's interest for 1/4 of the cost of Starr and his firm. The 152K PDF file is noted at investigation report page 37. but can't be opened. So for convenience, I included that page 1 from that report, in my presentation.
Okay,
So
Mr. Are-
this law firm of Buchanan, actually, so this whole cost savings that Gruskin is presenting, that he's saving all this money, well, if Starr was doing all of the legal stuff and he left and now he can only do 20 hours a month or whatever, they had to go out and hire another law firm for 1/4 of the same price to now handle some other aspects of the county's legal service, service needs. So it's nonsense to think that there was only one, and the county has had county attorneys in the past, and they come and go, they change. They actually change on kind of a regular basis. So I don't know, how do you make that a sole source if they didn't document anything, they didn't ask anybody anything, and yet this contract with Buchanan went into effect in January of 2016.
And thank you, Mr. Gill and Mr. Gruskin. Again, you have addressed this in writing, but you want to add anything other to this provision?
I do. Thank you, Commissioner. Number one, this is outside the Code of Ethics. Number two, the acknowledgement that sole source bidding is appropriate for consulting and professional services is undisputed. Number three, when authorization is required above the elected official level, well, these were decisions that were made by elected officials, and therefore it wasn't required. But even if it was, Exhibit M as submitted were the minutes of the commission meeting that considered this issue. Whether you agree with the justification in that discussion as reflected in the minutes or not, doesn't change whether or not there was written justification attached to the documentation requiring approval, which was the draft agreement. I'm sorry, Mr.
No, I don't want to cut you off.
Well, actually, it's not such a bad idea to cut me off.
Yeah.
But let me also say this. The suggestion that an attorney providing a very narrow range of services, as in the human services legal contract identified by the complainant, and extrapolating that is somehow the same legal job as someone who provides an array of legal services is a little bit like saying, if you want a cancer excised, go to a podiatrist, because you know what? They're doctors too.
Okay. And just to be clear, you, I think, have added to the matters already identified in your response. You're saying that the actual documentation and the process is in compliance with this section. Is that my understanding of your answer?
That's correct. That's correct. I may dispute whether or not this is an ethical issue, but even if it were, there is a written statement of the justification for using this particular sole source for contracting legal services.
Thank you, Mr. Chair. Thank you, Mr. Gruskin, Mr. Gill.
Any further follow-up from the other commissioners? All right. I think I promised at the time we were having public comment that if there was public comment on one of our specific agenda items, we'd take it in connection with that agenda item. Is there any public comment that needs to be heard on these complaints, the Archuleta County Legal Counsel complaint? Yes, sir. Yep.
It was very much music to my ears when I heard you say that your bailiwick is...
Mr. Chairman, I'm sorry to interrupt, but for the record, can we have the speaker identify himself so that...
I identified myself before. I'll be happy to do it again. My name is Stephen John Nalty. Okay.
Thank you, Mr. Nalty.
Again, it was music to my ears when I heard you say that your purview is government ethics. And you said a couple of things that your purview is not. And most of this hearing has been taken up with what is not your purview. I want to point that out. Government ethics. There is a maximum of law that says what is self-evident need not be proven. I don't know if you've heard that before, but it's a maximum of law and centuries-old truth. And I think that's what you're here for. That's what ethics is about. It's about the truth. And to back up a little bit, let's talk about truth. This is a pocket constitution of the United States of America. This takes from the original Constitution for the United States of America, ratified in 1789, and it didn't change a word in Article 6, where it says, in paragraph 2, or clause 2, this Constitution and the laws of the United States which shall be made in pursuance thereof, and the treaties which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary, notwithstanding. Which means if it's contrary to the supreme law of the land, it has no standing. My ears were blistered by the word statute, as if statutes are the supreme law of the land. Statutes, if you take the time to study statutes, you will find that every single one of them is contrary to the supreme law of the land. Further, Clause 3 says, and I'm struggling because I don't have my readers with me, the senators and representatives before mentioned and the members of the several state legislatures and all executive, now I said all executive and judicial officers, both for the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. What in the world has happened? Talk about ethics. This is a copy of a certified copy of an oath of office. I have personally reviewed hundreds of oaths of office of elected officials in Colorado. The language in this is very much the same as all of those. And it says, and I'm not going to tell you whose oath of office it is, doesn't matter. I blank do solemnly swear by the ever-living God that I will support the Constitution of the United States and of the state of Colorado and faithfully perform the duties of the office of whatever they're taking. Now, why do I point this out? Why do I point this out? The reason is we're talking about ethics. We're talking about common sense. There is no need to get lost down the statute rabbit hole. It doesn't say, I solemnly swear to support the Colorado revised statutes. It doesn't say that. It does not say that. And so, you're lost in this 21.1345 or whatever the hell it is. No. We're talking about ethics. It is self-evident that what Mr. Starr did is unethical, and I think your findings should bear the same.
Good afternoon. Good afternoon. My name again is David Kofelt, and I sat as I listened to this entire proceedings. One of the key components of this whole issue is whether there was any looking for a word here, conflict of interest. I worked in the insurance field for over 20 years. I know for a fact when there's a husband and wife together, one spouse is getting a contract, the other spouse is not yet. But if that spouse receiving the contract was to pass away, where's the conflict of interest? The surviving spouse definitely has rights to whatever financial gain was there in that contract, even more so when the surviving spouse is now running the whole show of that law firm. So that's the first point I want to make. The second point I want to make, I heard over and over again, does this ethics committee have authority, have jurisdiction over a local county government? I forget the name of the county, Achuleta County, something like that? Well, here is, I sat there and I pull up the organizational chart of the state of Colorado, and guess what? Under this organizational chart, I'm sure you all are all aware of it. As I look, this is state services, I presume you fall under, and going down to agencies managed by government, as I look in the middle column, make sure I put my readers on here right. Division of Local Government falls under your jurisdiction as Ethics Committee. If the state of Colorado has jurisdiction, so do you. I yield with that. Thank you.
Thank you, sir. Anyone
If I
else?
may,
Just a minute, Mr. Gill. Oh, Mr. Keno.
no, it's Mr. Keno.
Okay, Mr. Keno, you're on.
All right. First, I would like to say that everything that I'm about to testify to right now is the truth and the whole truth and nothing but the truth. Because it was entered into the record by Mr. Starr, I would like to address a fabricated story that has become part of the record of this commission. And that is that Mr. Gill and several other members of the Archuleta County Guard submitted a subpoena and then a warrant for Mr. Starr's arrest. These facts are untrue. The Archuleta County Guard, which I'm a member of, had absolutely nothing to do with that. I was sent a subpoena by the Colorado People's Grand Jury for an investigation that they were doing into Mr. Starr's conduct and CTSI. Nobody in the county guard knew anything about this until the day before. I believe I contacted Mr. Gill, and I informed him that he should come to the county commissioners meeting and that I would be serving Todd Starr from the People's Grand Jury. I didn't know exactly what was in the subpoena myself until I received it via mail, at which time I went to the county commissioners meeting and I served Mr. Starr with the subpoena. And it's all on YouTube. No one here in Archuleta County knew anything about it except myself until the day before. Then he was given ample time to answer the subpoena. At that time, I believe it was about 60 days later, the best that I can remember, the People's Grand Jury for the state of Colorado issued a subpoena for Todd Starr's arrest. Again, this subpoena was sent to me because I am an administrator for the People's Grand Jury of Archuleta County. It was sent to me, and I informed no one of this fact I took that subpoena to our sheriff, Rich Valdez.
Mr. Keenan, let me interrupt you for a minute, and I do this for your own benefit as well as for ours. I think I can assure you on behalf of the commission that we're not giving any weight to, nor are we drawing any conclusions based on the issuance of any people's grand jury subpoena, any activities of the Archuleta County Guard, any militia sort of,
We are not a militia, sir.
well, I'm just trying to come up with a word to shorten my description. That's not any part of our discussion, and I mean, you're free to continue to speak if you'd like, as you have the right under the First Amendment to speak. You have the right to make public comment, but I'll leave up to you the wisdom of doing that. I'll leave the legitimacy of the people's grand jury and any process that is issued. That's between you and the FBI and other law enforcement agencies that may have an interest. You may or may not want to talk about that in its public forum, but I can just assure you that it doesn't have anything to do with our deliberations today.
Sir, I will be more than happy to address this issue in a public forum because this relates back to Mr. Starr's ethics. Because Mr. Starr fabricated this story, which was a total fabrication on his part. So how does that speak to his ethics? This is an Ethics Commission hearing. And that's why I'm addressing this, because this clearly shows the ethics of Mr. Starr, because he fabricated this story, and it was allowed to become part of the public record for this hearing.
All right, sure. Well, like I said, I don't think that's going to bear any relation
Sir, I
to
had
our
to address
decision.
it because I've learned one thing in my life. If a lie is allowed to stand, then it becomes the truth. I cannot let this fabricated story stand because it is an outright lie. With that, I'll yield, sir.
Okay, thank you. Anyone else?
Mr. Chair, could I just clarify for the record that the previous speaker's references to subpoenas and grand juries don't actually refer to state-authorized subpoenas or grand juries. They are private documents and gatherings, and I just don't want, with the live streaming, I don't want there to be any implication that there's been some sort of legal authority that's been brought to bear as to Mr. Starr.
I think the commissioners understand that, Mr. Gruskin, and we appreciate it, but I think you've clarified it for the public record and the streaming record. And I think, as I said before in a pre-hearing conference, this commission doesn't recognize any legal process other than that that's been issued by a duly constituted authority under the Constitution, as to which we all are bound. All right, if there's no more comments, we're going to close the public hearing. And commissioners, what's your pleasure? You want to deliberate and make a preliminary decision? I think we'll probably need a written order in this case eventually, and we probably won't be able to review that till our next meeting. But it's our custom often to deliberate, to seek legal counsel if we think that's necessary in an executive session. So what's your pleasure?
Let's do that.
Deliberate or seek legal counsel?
Seek legal counsel.
Legal counsel.
Okay. Is there a motion then to enter into executive session pursuant to state statute to obtain legal counsel from our lawyer?
So moved.
It's been moved and seconded.
Mr. Chairman, did you want to cite a statutory reference for that?
If you can give me that cite, I'm happy to cite it.
It's in the agenda. Hold on for a moment.
(24.6.402.3A2).
That would be correct. 24.6.402.3A2 and 1390.107.1B.
What he said, a motion pursuant to what Dino said to go into executive session. I think what we'll probably do, ladies and gentlemen, is we're going to go into executive session. We're going to get our legal advice. We're going to eat our lunch. So I would not expect us to be back into public session for at least 20 or 25 minutes, I would say. All those in favor of going to an executive session, say aye.
Mr. Chairman, may I ask just one question about your executive session?
Sure.
Will the commission treat as admitted the exhibits that are public documents in one way or the other, basically exhibits A through V of the respondents for purposes of its deliberation?
Yes. Everything that's been submitted will be part of the administrative record for our deliberations and our decision.
Thank you.
Okay? All those in favor of going into executive session, say aye.
Aye.
Any opposed? There are none. We are in executive session. We need to. We're back in session at 3:02 PM for the December 10th, no, excuse me, the August 10th meeting of the Independent Ethics Commission. Commissioners, are we ready to,
You want to see if there's somebody on the phone?
You gonna turn the camera back on?
the camera's on, it's on a 45-second delay, Mr. Giel, so it'll be coming to you shortly. All right, Commissioners, are we ready to deliberate on these complaints? And I guess we have a group of complaints here. They are get the numbers down. These are complaints 1531, 1532, 1533, and 1534. Who would like to start? Commissioner Bacon, you want to start?
No.
Commissioner Jones, you want to start? Or you want me to start?
Right.
Actually, Mr. Chairman, I think it'd be more complete if you started.
Okay.
The camera's still not on.
I'm sure it'll be coming to you. Let us know if it's not on in another minute or so.
It's on here.
Okay, good. Okay, so this is the part of the meeting where each commissioner gets a chance to state their views about the complaints, the allegations in the complaint. I'm going to just make my comments relative to all of them as a group. And I'm going to start at a very high level, and then I will go down through some of the individual allegations. So at a very high level, I view our job typically to, where I view our job as reviewing ethics issues, as I said earlier. And typically those ethics issues involve things like conflicts of interest or self-dealing or cashing in, obtaining personal financial benefit from public service. They do not involve, in my view, becoming a special administrative appellate board for every perceived wrong of government functioning. And in a case like this, you can see from the discussions we had earlier and from the comments of the various participants, sometimes those things blur. But I'm going to give one example of the difference so that people really have it etched in their brain. We do not serve as an appellate board for procurement code violations. You could have a procurement code that requires the Board of County Commissioners to get 3 quotes for every contract over $10,000. They could walk in and get 2 quotes for a contract for $1 million. They could willfully, wantonly, and intentionally violate the state procurement code and the county procurement code and the federal procurement code, and that would not raise an ethical issue for this board. We are not a super appellate board for enforcing procurement codes or state budgets or state budget laws. On the other hand, if a procurement code had something in it that related to ethics, like thou shalt not give a contract to the mayor's wife or the mayor's children, and the mayor voted to give a contract to the mayor's wife or mayor's children, that would raise self-dealing, conflict of interest, something like that for me, and that would be something that our commission would be concerned about. So to the extent that concerns have been expressed about, was this a good contract? Could the county have saved money if they had hired a different outside lawyer? Could the county have saved money if they had hired another in-house lawyer? Could the county save money by hiring the social services lawyer for $75 an hour instead of $300 an hour? None of those issues are issues for me that relate to this commission. We don't second-guess the decisions of county officials or elected officials, and they are accountable, as are all elected government officials, to the voters in their districts and their counties and their cities. And if the people of Archuleta County think this was a bad idea, I have no doubt that the people of Archuleta County know everything there is to know about this contract, and they will visit their vengeance upon the elected officials if they agree with that. And that's the sort of what you do as a public official. You make what you think are the best decisions for the people, and some days you get the reward, and other days you take a beating. But it's not for the Ethics Commission to decide whether or not this was a wise decision or not. Similarly, in my view, our commission needs to be extremely cautious, especially in the area of legal ethics and judicial ethics. For the most part, we lack jurisdiction over those questions. And one of the things that we would have to do in order to find a violation here would be to take the state statute. Let me see if I can get the citation right. 24 CRS 18201, which is the statute that talks about a 6-month period after which you, if you're an employee of an agency, there's a 6-month waiting period before you can do certain things. I'm not going to try and repeat the statute. But one of the questions that I have in my mind is whether or not it's a wise thing for this group to interpret that statute in a way that it applies to lawyers who are continuing in service representing the same party. It's very easy for us to look at that statute and say, well, clearly, if you are working for the state agency and you leave and join the other side, and you want to come back and be adverse to your former client, be adverse to the agency that paid you and hired you, take advantage of the information you learned while you were that employee, and now use that information against the agency, it's not difficult for us to see an ethical issue in that kind of a scenario. But I'm unaware of any other case that's been presented to this commission or elsewhere that has dealt with the situation where a former government employee is being asked to continue service in exactly the same capacity as they were before, only now as an outside lawyer. The legal duties of an in-house lawyer, an employee county attorney, are exactly the same in every respect as they are for an outside attorney employed by a law firm who's been hired by the county to represent the county's interests. From the standpoint of the Legal Disciplinary Board and the Colorado Supreme Court, there is no difference. A lawyer is a lawyer is a lawyer. The lawyers owe duties of loyalty, trust, candor to their clients, the duty of zealous representation, and so there is no level at which I see that there's been any change of loyalty, change of duty, change of obligation in Mr. Starr's position simply by virtue of the fact that he's gone from being an in-house attorney to an outside attorney for the county. He continues to be bound and obligated to act in the county's best interests. He can't take on clients that are adverse to the county and represent them against the county, at least not in a way that would take advantage of or misuse confidential information. And all of that relationship is governed by the rules of legal responsibility and legal ethics that the state Supreme Court has created to govern lawyers. And the right of a client, in this case the county, to hire the lawyer of their choosing, the lawyer that they are willing to put trust and confidence in, a lawyer that they feel that they can rely on, is the same as any other client has to hire an attorney of their choosing. Anyone in this room on the phone that participated in this hearing who had been accused of a wrong or sued in a lawsuit or prosecuted by the government would want the right to pick a lawyer of their own choosing. And they would not want an unelected board like this regulating unduly the right of that client to choose a lawyer. If any board or body is going to interpret this statute with the 6-month period as being applicable to that very sort of sacred relationship between lawyer and client, and find that a government lawyer cannot leave the government and then continue to represent the government with all those same duties, if anyone is going to find that that's a violation and that violates the statute, in my opinion, it ought to be the state Supreme Court or the Supreme Court Grievance Board or the people that are responsible for protecting the attorney-client relationship. And I, for one, am very reluctant to step into this particular relationship and declare that, we know better than the people that regulate lawyers, and we know better than the clients that have to choose and hire lawyers. And we know better than the voters of Archuleta County who can vote people out of office if they don't like this choice, and have us step in and say that this was some kind of ethical violation for Mr. Starr to continue his representation under the facts and circumstances here. So, and that's all setting aside the idea that it would appear from the undisputed facts in the record that the county is probably saving money by doing this. We don't know precisely how or why they're saving money. It probably means that Mr. Starr was probably underutilized when he was a full-time city or county attorney, and instead of spending his time doing high-level legal work every day for 8 hours a day, he was probably doing a lot of other non-legal things and answering a lot of questions and being an advisor to the county, and a lot of what he was being paid for didn't have a lot to do with the legal work. I'm speculating a little bit now, but those of us that have had experience with local government and had to counsel clients about hiring in-house lawyers have seen that over and over again. Every company, every city, every county, every school district has to decide at some point whether it's better to have a full-time lawyer in-house that you can call all day, every day, or is it better to go outside and hire legal help when you need it? And everybody knows that when you go outside to a law firm to hire that help, you're going to pay more per hour, and you're going to get fewer hours. But there are circumstances where you actually save money doing that, because the alternative is you got to pay for a lawyer 8 hours a day, 5 days a week, 52 weeks a year, whether you need them or not. And that's very expensive. So that's one of those decisions that, in my view, the Independent Ethics Commission is not, designated to decide. We don't get to decide whether the county is better served by having a full-time in-house lawyer or an outside law firm. So I'll try not to be too long here with my comments, but just from a purely practical, common sense, as was referred to us, ethical standpoint, that's kind of where I start, which is, is there anything about this decision that seems corrupt in the sense that any of these 4 commissioners got any personal benefit from this decision? I don't see it.
3 commissioners.
3 commissioners and an administrator.
Yeah.
And is there anything that suggests to me that the attorney in this case, padded his own bed or did feather bedding before he left his official position? There's a whole bunch of facts we could make up here that would make this a different case. Sometimes lawyers that are working for companies know they want to leave, and they start sending legal work to a law firm to curry favor with the law firm because that's where they know they want to go to work. And they send that work there, even if it's not the best law firm, and then they go get a job there, and miraculously, now they're going to be representing the client. And that raises serious questions about whether or not the attorney, when he was performing his job for the county, was exercising good faith, independent judgment, or was he just feathering his bed for going out? We haven't seen any evidence to suggest that that was the case here at all. If there's anything the least bit troubling here, I suppose one could question, whether or not, as an in-house lawyer performing your fiduciary duties, is 30 days' notice adequate? Could more have been done to search for alternative lawyers? Are there lawyers in Durango that could do this job fine? But, all of those things are really, again, not ethical concerns for our commission. They have to do with whether this was a good practice or a good process or not. And they have to do, and they can all be remedied. If the commissioners decide that this was a bad idea, they can replace Mr. Starr. If Mr. Starr decides this is a bad relationship, he can quit. If the voters decide this is a bad deal, they can vote accordingly. So, again, I don't see any of that raising the kind of entrenched ethical issue that we are supposed to be dealing with. So having said that at a high level, at a common sense level, then I turn to what does the statute say, what does the amendment say? And, every once in a while, the law is different than what you think it is, and it makes you do something that you don't want to do, or makes you do something that's counterintuitive. But in this particular case, I don't think that's the case. I think that my observations at 50,000 feet about whether this makes common sense are supported by the law. And we are governed by rule of law, and we try to make our decisions based on rule of law, and not based on speculation or political theory that's not embraced in law. We live in a country where the Constitution creates governments and the governments make laws, and the law has to be predictable, and we can't just do what we want, and we can't create institutions that aren't sanctioned by law and have them make laws or make rules. So for better or for worse, I'm constrained to look at the laws that we have on the books that are applicable to this commission. And to begin with, our commission is created by the constitutional amendment by vote of the people. So we do have some leeway. We don't have to follow statutory law that we think is inconsistent with our constitutional mandate, but we are authorized to look at statutory law as a guide to help us figure out what's ethical and what's not. And in this case, there have been several specific provisions pointed out to us that we that I've considered at least in reaching my decision. And that is, and I'll cycle through those. One legal principle that was cited as the basis for a violation here was the possibility or alleged breach of fiduciary duty by Mr. Starr in connection with this. I would find that there's been no breach of fiduciary duty in this case whatsoever. I would find that Mr. Starr's fiduciary duty to his client, both as an in-house lawyer and an outside lawyer, is unchanged. I would find that he acted in the best, with the best candor. He disclosed to the board his interest in leaving. He disclosed the place he was going. There's no indication that he misrepresented or lied to the board in any way about his capabilities or the capabilities of his new firm. He behaved with candor and with honesty, and so far as we know, with loyalty to the interests of the county, both before and after he left as an attorney. So I would find no breach of fiduciary duty. This is not a case, by the way, I said earlier that you could imagine cases that would cause issues. This is not a case where we see Mr. Starr, for example, going to the county and saying something like, I'm the only guy that can do this job, and so sorry, we have a hearing next week, but I'm going to leave. If you want me to come back and do that hearing, it's going to cost you, twice what you've been paying me, or 3 times what you've been paying me, or 12 times what you've been paying me, and I'm going to take advantage of the situation to enrich myself. The agreement, although it calls for a higher hourly rate than Mr. Starr was receiving as an in-house lawyer, it probably saves the county money in the long run, and it creates an advantage for the county in terms of eliminating various liabilities associated with having an in-house department. So I don't see that there was any overreaching or bad faith on that, and I would find that there's no breach of fiduciary duty. The second standard that was cited to us was whether or not there was a use of confidential information here to further a personal interest. We've not been cited to any. I would find again here that there's been no misuse of confidential information that was given to Mr. Starr in his capacity as an attorney, as a county attorney, for any purpose other than providing legal services to the county. The misuse of confidential information, as we talked about earlier, typically occurs when information is given to a person, the information is confidential, it's given for a specific purpose, and then that person misuses the confidential information for a purpose other than it was intended for. I don't see any set of facts under which that could be the case here, because Mr. Starr, to the extent that he has confidential information from the county, was, and will continue to be duty-bound to use that information for the benefit of the county and for the benefit of his client. The third standard that was cited to us was 24-18-105-3, which just a minute. (24-18-105-3), which has been referred to as the revolving door provision. Under that provision, as I read it, the requirements of a violation would include that the government employee, within 6 months after termination of his employment, then accepts employment that would allow him to take direct advantage, unavailable to others, of matters with which he was directly involved during his term of employment. Then the statute gives examples of the matters, and the matters that are cited all have to do with applications, claims, or contested cases in which the employee was active as a participant while employed by the government. And my view of this provision, read as a whole, taken in context, is that it applies to a situation of side switching where a government employee leaves and goes to work for somebody else and then misuses or takes advantage of his prior employment to get the government to do something it otherwise wouldn't do. And I'm not seeing that here. I also note that the statute itself excludes from its provision what they call rules of general application. So the concept there would be, even if you're a government employee, and as a result of that work, you become aware of and knowledgeable about and experienced with rules, regulations, and functioning of the government, because that's your job, and you're spending all of your time focused on these matters. But this is all information and knowledge that's available to the public if someone else wants to spend 40 hours a week becoming familiar with it. That is not the kind of information or the kind of taking advantage of that's governed by this statute. It specifically excludes that. So in this case, the fact that Mr. Starr, because of his work as a county attorney, became knowledgeable about county rules and ordinances and statutes, learned everything there was to know about the county and its politics and its land use and its zoning and whatever other facts about the county may have been pertinent to the performance of his duty, to the extent that all of that information is public information, and almost all of it should be public information. Under this statute, at least, it doesn't seem to me that his continued use of that general knowledge and experience is specified in this statute as being improper in any way. And it would seem to me a very bizarre result if we were to come out with an ethics rule that prohibited state or local governments from being able to take advantage of knowledge of capable people to provide good services. And so I would find that there's no violation of 24-18-105-3 insofar as it relates to ethical rules. The next rule cited to us was 24-18-109, which has been cited in the briefs, the respondent's brief, as the economic benefit rule. I would find there's absolutely no violation of this statute as well. This one, to me, is easier. The statute contemplates that no public employee should perform an official act that directly and substantially affects its economic benefit. And here, the undisputed facts are that Mr. Starr did not commit an official act relative to his employment. He did not approve his own hiring. He did not opine to the county about his own hiring. He did not vote on it as and for the most part, an official act has to be a vote or a decision or something that actually is the exercise of official authority to commit the government to a course of action. There's no evidence here to suggest that Mr. Starr committed such an act in connection with his own retention. Insofar as the other respondents did commit an official act in hiring Mr. Starr, there's absolutely no evidence that they had a personal financial interest in this decision that would constitute a conflict of interest or a self-dealing of any way. This would be a different matter if one of these other commissioners, was a member of the law firm or had some other financial interest in the law firm, but we haven't seen any of that. I don't see how, on the record before us, how one would question the motives of these county officials. If they make a bad decision and hire a bad lawyer or spend too much money on the lawyer or the lawyer doesn't get the work done for the county, they're going to be accountable for that. So their incentive, their motive is to hire a good county attorney who can effectively represent the county, and that inures to their benefit. I don't see an obvious incentive for them. Now, we can speculate that, there was a close working relationship between the county and the lawyer, Mr. Starr, and perhaps there was some affinity between them. There was a friendship between them. Wouldn't that cause the commissioners to prefer Mr. Starr over other attorneys and maybe hire him when they could have done a wider search, a broader search, and found a better attorney? I suppose all of that is possible. And there are some ethical regimes in some places that make it completely improper to have any contact with your former agency. There are cooling off periods that are specified in federal law for specific positions that prohibit in very fine detail what the former federal employee can do with the agency. Some prohibit any involvement at all in matters. Others prohibit you from going back to your office and lobbying. Others prohibit you from appearing before a court or an agency for a period of 6 months or 12 months. They delineate very carefully between the level of the employee. All of that, all of those ethical standards are carefully tailored by government decision makers who have to balance the importance of being able to take advantage of experience on the one hand, even when it leaves the government, and maintaining an appearance of propriety or impropriety on the other hand. Those fine balancing decisions, I think, are not implicated here for the reasons I've previously stated. The next provision that cited to us as a potential violation was 24-18-201. 24-18-201 is probably the most difficult of these provisions to analyze, and I think has required us to be the most thoughtful. It is prescriptive. It's not just a guide, as some of the other provisions are. It specifies, it's vague in its formulation and its the words that are used. It says that a former employee may not, within 6 months, contract with any local government involving matters with which he was directly involved during his employment. Involving matters with which he was directly involved during his employment. As I indicated during the questions I was asking, I can think of lots of situations that would clearly violate this provision. And those are easy cases. And they have to do with situations where a government employee learns about something that the general public doesn't know about, and they go out like a new project or a new convention center, and they leave their employment because they want to cash in on that knowledge, and they go out using that knowledge and that information to buy property and derive a personal benefit, and there's nothing public-oriented about it. The money's going into their pocket. It's not a service to the government agency. There's no ongoing duty of loyalty to the government agency. It's just a kind of a rank effort to cash in on information about a matter with which the person was directly involved. The issue here is that requires us to stop and consider is there anything unfair or unethical in the context of an attorney-client relationship about a lawyer who inevitably has possession of confidential information and knows a great deal about the client from working for that client within 6 months after the attorney leaves the employment of the government. It's very hard to say that that knowledge and information that's in the attorney's head and in the attorney's possession is not of value. It'd be almost impossible to say that that was not a factor in the hiring of the attorney by the commissioners. I think Mr. Gruskin has been open about it, and I think Mr. Giel and Mr. Gruskin have agreed that in fact, in a very large way, it's Mr. Starr's knowledge of the county, his familiarity with its affairs, his facility with its legal issues that is driving the decision to hire him. I guess the question for me, when you step back on a common sense level, is you say, well, is there anything unethical about that? Is there any part of my ethical construct that is offended by the idea of an attorney who's bound by all these ethical rules and obligations of loyalty, or a county that relies on that person for advice? Is there anything that smells bad to me about that person continuing to use his skills and his knowledge and his expertise about the county to provide good legal representation to the county? And I just can't find it. I just can't find anything in my ethical makeup or in the golden rule or in any written standard of conduct that makes me think that's a bad idea. Now, that's different. There, like I say, you could make up a lot of different situations here that you'd say, this troubles me. But this is just not one of them, not on those set of facts. So I would say, I would find that there's no violation of 24-18-201, because I would not interpret 24-18-201 to apply to this particular set of facts. I would not rule or hold that this provision is never applicable to an attorney. I wouldn't hold that it's never applicable to an attorney-client relationship, because I can think of circumstances where it might be problematic. But I don't see in this particular case facts that would cause concern from an ethical standpoint. That leaves us with the procurement codes. And I think I've spoken to those a little bit. I would find that there's no violation of either the state or the Archuleta County procurement codes for several reasons. One is, I think I would find that the state procurement code is by its terms not applicable to the county. It's applicable to executive departments of the state. But secondly, I would find that even if it is applicable to the county, or even if the substance of that code has been incorporated in the Archuleta County Procurement Code, I don't see a violation of that code insofar as it implicates an ethical provision. And for that, I have to distinguish between two different kinds of provisions in procurement codes. There are those kinds of provisions that are based in ethics, and there are those kinds of provisions that are based in good government. An example of the first would be, as I said earlier, a provision of the procurement code that prohibits contracting with the mayor's wife. That would implicate ethics to me. A second provision, a second example would be one that requires a certain number of bids. And as I said earlier, unless the violation of the procurement code rises to an ethical standard or implicates self-dealing or a conflict of interest, I would not find that it's an ethical violation. If it's merely a failure to follow a procurement code or failure to, for example, get the right approval in writing, it may or may not be a violation of the procurement code. But we would not cite a person for an ethical violation because they failed to obtain the necessary approval in writing. That's an error or a deficiency in the administration of the procurement code. It's dealt with by normal administrative processes in the county, and there are other agencies that deal with that. That's not our province. So for all those reasons, and I know this has been a kind of a lengthy diatribe, and I apologize. I don't mean it to be a diatribe. I just mean to be thorough. I would find that there's no ethical violation on the facts presented before us, that the evidence indicates that the county acted in good faith, whether rightly or wrongly. We don't pronounce judgment on that, and that Mr. Starr did not engage in unethical conduct in any way by offering his services to the county to continue as an outside attorney. That's what I would do, but everybody has their own opinion. Commissioners?
Thoroughly and well stated, Commissioner.
Commissioner Smith?
Thank you, Mr. Chair, and I'll just add a couple of comments to the points. There are many matters here in front of us, and in fact, I think quite honestly, the commission in its previous meeting cast the net broadly to encompass a number of matters that might find facts to fill in. And having gone through this process, I want to thank the participation of all of the parties. I think the parties have worked to supply the information to the commission, and I want to thank you for doing that. There are only two sections I'm going to highlight. The chair has gone through a lot of them, but there's two sections I think in particular. One is Section 24-18-2011. And as the chair has said, this is a difficult question, but it's not a new question for the commission. The commission has taken it up before. The only reason I really want to speak to this is this commission works very hard to be very consistent. We handle matters in the form of complaints, we handle matters in the form of letter rulings, and we handle matters in the form of advisory opinions. And I would concur with the conclusions of the chair, and I would state for the record that had this matter been presented to the commission, the outcome would have been the same. Commission as an advisory opinion, the outcome would be the same. We had a case here in 2013. I looked back through the record. We failed to put anything in the record, but I know that it's the Durango case. And I think one of the rationale, at least espoused by some of the commissioners, we tried to judge the case the same way we would have had it appeared in front of the commission as a request for permission or some prior guidance versus whether or not it's a complaint. And we were pretty steadfast in determining that we would treat those matters the same. And I just want the public to know and everyone to know in this case, had that matter been presented to the case. I also think it's important, the respondent has emphasized in its briefing its recitation to advisory opinion 1008, letter ruling 1002, and advisory opinion 1305. But one of the things the commission has applied repeated requests is we do look to the guidance of the agency as to whether or not there's a conflict. And we would certainly have done that whether this was a request for an advisory opinion and do it here. And I think the outcome's the same. And I'm just adding those comments to what the chair has already offered. I will admit where I have struggled the most in this case is regarding the procurement code. And I have wrestled with the procurement code, tried to make some sense of the procurement code. And I have to say that I think it's wonderful, number one, that Archuleta County has a procurement code. And from all accounts, I think generally does a real good job in enforcing that procurement code. That code, by the way, gives some public confidence to what matters are going on. I think the other thing I struggle with, and I don't know where it fits into the whole scheme, whether it applies to any other provision, but I think it's crystal clear at the conclusion of the evidence that the commissioners in this case acted to save the taxpayers' money. And to the point that the chair has made, our focus needs to be on ethics. I want to state for the record that in looking very closely at the procurement code, it is not the obligation of this commission to interpret that code. I think if I were to give any advice to folks in the future, I'd try and be a little more explicit, but that's not really the role of this commission. I probed pretty hard at the end of the proceeding to see if any of the parties could identify more of an ethical component, how they saw this issue, and really tried to make that determination. But at the end of the day, I'm left that I don't believe the commission has evidence in front of it that there has been an ethical violation under the Archuleta procurement code, and I would join the chair in the conclusion on all of the specifics of the matters reviewed by the commission.
Commissioner Jones?
I would add briefly but specifically that with respect to the issues we went over with respect to 24-18-105, which is the revolving door, and we've already discussed, Commissioner Leone discussed in detail some very good points with that. I would also like to underscore that it is for guidance only, and it's prescribed in the beginning of 24-18-105. So for that reason also, I would not find any wrongdoing. And with respect to the cost savings, I agree that appears to be within the discretion of the county itself. I would note that it appears that having the $72,000 a year for 20 hours is as reasonable on its face as doubling that and having 144 when they were already at, pretty close to that. So I don't see that as troubling, even if it was our concern. But I do believe that in any event, just for, as a matter of course, those are issues for your voters to decide. I would, if there was anything that I would look at doing differently for others in the future, if they wanted to take it into consideration, it would be perhaps to open it up to others so that you don't get the frustration of your community. And even if you know that you don't have anybody else qualified, give that some consideration. But that's not for us to say here today in terms of finding any sort of violation.
One brief comment that many of these are political questions, and if we can't get our will in the political world, sometimes we try to term it elsewhere and make it ethical. And so, of course, the voters were wrong in selecting these people to make these decisions. So therefore, they must be unethical. And so if you can't change it politically at the ballot box, I think we need to be honest about what is ethics, and certainly the constraints that this commission has with Article 29 of the Constitution. And we have very limited power. All of us certainly want to be ethical, but ethics sometimes depends on the interpretation of the individual saying it, but we are constrained by the Constitution and the laws there. And so those people who feel as though government is not doing its job, sometimes they need to run for public office and try it.
And I would say the commission did set out a series of statutes and possible violations to investigate. So I feel like the commission made an effort to be responsive and to do what we could do within the parameters of the statutes, which we are subject to. And the fact that in doing so and with the Dino's investigation, we didn't find additional facts on our own to substantiate the claim does not take away from the fact that the commission did make an attempt to investigate and do its job. So I commend the commission for that.
Thank you. Okay, so I'll also tell you what we think the course of action will be. The commission will prepare a written opinion or written findings of fact and conclusions. The way that works, because of the strictures of the Open Records Act and Open Meetings Law and so forth, Sunshine Act, is that our staff will prepare a draft of an opinion in consultation with our legal counsel. At some point before our next meeting, we'll look at that draft. At some point, we will probably make that draft available to the parties to look at, and we'll let you comment on the draft. And then in an open meeting, we will deliberate about the draft, the proposed changes to the draft, and issue a final written opinion. That's typically how we do it. And I can't promise what the timing of that will be. I think we've got some discussions ourselves to talk about in terms of our schedule going forward here. Mr. Gill, I'll start with you. Anything further from you?
I'm not sure the commissioner's name that is sitting just to your left.
Commissioner Jones?
Yes. Mr. Gruskin actually included actual pay for the first 6 months of this year for Mr. Starr, and you might want to look at that as far as actual totals just for your reference. It appears to me, and I'm not a lawyer, that the ethical part of the state and county procurement code and its actual wording is being, it's receiving a special pass because we're talking about one of your fellow Bar Association members. And so it sounds like right now, and I didn't really expect much different than this, that the county handing Mr. Starr a $6,000 a month contract to start his private law practice, in your opinion, is not unethical. So I don't, what else is there to say?
I think you've been listening very carefully, so I think that we'll have a written opinion that will come out, and we thank you, Mr. Giel, for your participation and for the effort that you've put into it. We know that it's a difficult burden, and we know that you're well-intentioned, and we appreciate it. That's what makes the system work. We have heated debates, and sometimes we have disagreements, and people come before a body like this, and somebody's going to walk away disappointed, and somebody's going to walk away less disappointed. But we appreciate your participation. Mr. Gruskin, anything from you?
Just curious, Mr. Chairman, will the commission vote as to a no violation? I took from the comments of the four commissioners that none of you find a violation. Will you vote on that today, or is that something that you defer until you have a written decision?
You know, we've done either. We've done both, and I'm happy to have, I'm happy to poll the commission. How about that?
Well, and I think that would be appreciated, the reputational interest that I spoke of at the outset.
Understood. We tend to not take our final formal vote until we have the actual language of the opinion in front of us, so that everybody's in agreement, not only on the result, but on the reasoning that we get to. I know it's a little weird, but it's the weirdness that comes with having a commission performing an adjudicative function.
Okay.
It's not quite as simple as when you wear black robes and have complete control over everything. So if it's all right with the commissioners, with the pleasure of the commission, I'm happy to take a poll of the commission on the question of whether or not we are in concurrence that there's no violation of the code of ethics and that the formal opinion will follow. All right, let's take a poll of the commission. Commissioner Bacon?
Aye.
Commissioner Jones?
Aye.
Commissioner Smith?
Aye.
And I vote aye as well on the question. The commission finds that there's no ethical violation and the detailed opinion will follow. And that's with respect to each and every one of the respondents.
Thank you very much, Mr. Chairman and members of the commission.
Thank you, and thank you for your attendance. I won't ask, I'm afraid to ask whether or not the county's legal budget has been exceeded as a result of this proceeding or not, but that's not our concern.
I'll plead the fifth.
All right.
Thank you, members. Is there anything else, or are we excused?
You're excused,
Thank you.
unless you want to stay and watch the rest of this meeting.
I'll watch it on the live stream.
Thank you both. Certainly. Mr. Giel, if we were here, we'd shake your hand too.
Thanks for your service.
Wants to shake my hand?
I said we would shake your hand if you were here.
All right, thank you for coming too. Appreciate it.
There's handshaking going on. Thank you.
Okay.
Thank you.
Yeah.
I bet a lot of backslapping
Thanks for
too.
your service. I know it's never always easy. Thank you.
Okay, we're through with the hearing for complaints number 1531, 1532, 1533, and 1534. We are significantly time constrained this afternoon on the rest of our agenda. So I think there are a number of things that we're going to roll over to the next agenda. I'm going to, unless, Dina, you tell me you have something desperate to report and staff report, I'm going to skip you, or can you do your staff report in 30 seconds or less?
There's just a couple of things. One, I know that one of the commissioners is not going to be available on our next meeting date, September 8th. We have the issue with interviewing the fifth commissioner pending. We haven't been able to get schedules lining up. So I think one of the first things we need to deal with is how we're going to deal with scheduling. And of course, as you know, if, among four of you, if one of you is missing, there's no opportunity to go into executive session.
So we need to reschedule the September 8th hearing?
Yes, sir.
I'm here. Yeah, I'm here. I'm here until the 16th.
Is everybody else here for that date?
On which date?
During late August, there might be a few days where I am out, late August. So 25th through the 29th, I will be out, I believe. Those are the dates.
Okay, I could do, how about if I just start throwing some dates out?
This is for what?
This is for our September meeting, our next meeting.
Instead of the 8th?
Instead of the 8th, right.
Well, Matt, they did exactly what I thought they would do.
Hey, Mr. Giel, you're still on the line. Do you want to be on the open phone, or do you want to have some privacy?
I thought I hit the mute button. I'm sorry.
Okay,
You hear me now?
yes, we can.
Oh, my mute button ain't working.
Mr. Giel, can we close the line?
Is your meeting still going?
No, we can still hear you. Can we close the line? Do you want to?
I'm watching you on the video and listening to you.
Okay, so we're gonna close the telephone line,
Does-
and you can follow on the video. How's that?
All right. Hey, I can give you, well, at some other point we can talk about the difference between your live feed and what's on, what's showing up on YouTube.
Okay. All right, we're hanging up the phone.
All right. Good night.
Okay, is everybody off the phone? Do we have anybody on the phone? Okay. All right, we're looking for another date, September 9th. Okay.
All right, and with that, quickly, we have the audit stuff coming up. We're expected to appear before the audit committee on October 3rd, if I remember. I have some materials for you in your packet. One is dealing with a complaint, one is dealing with a code of ethics pertaining to commissioners, or a code of conduct, rather. And I obviously am going to need your thumbs up before we can say that we've completed those items, but we can also maybe say that, you know, that we've done significant work. I mean, I don't know how you want to approach it.
What were the two items?
One is for the complaints. I put,
Complaint form, you mean?
yeah, it's the complaint form.
This
which
has
is-
to do with whether or not we have to specify the remedy?
That's correct, and there was also a bunch of information instructions on the complaint form on how to fill out the complaint, citations to our FAQs and the handbook and all of that. So that's what's in there.
Did everybody have a chance to look at that?
And where is this?
It's in the packet. I will tell you quickly.
Just, okay. I looked at the form, it looked fine. I read briefly through.
One comment on the form, as quick as I can, let's see, can I pull it up here?
It's on page, hold on for a second.
What?
It starts on page 486.
486?
Yes.
Okay, got it.
So there's instructions and then the form.
Okay.
So it's under the audit issues?
Yes, that's correct.
Okay. Let's look real quick.
Okay.
I like the form. I am trying to get this page to come up, do you know?
I'll get it for you.
I'm trying to get to 486 and,
486.
right.
There you go.
Okay.
There's
There,
the
when we
instructions
come
and the
up-
form is below.
And I like the way we've done it, but my question goes, okay, we're choosing public admonishment, okay, versus the fines, and that's probably okay. I really questioned the language, but after thinking about it, that's probably as close to language that I think we can do, so I'm okay with it.
Okay.
And I'll comment on that ethics code, I liked it,
You like that?
yeah.
Okay, so I'm good on the complaint form and the instructions.
What comments on ethics do you like?
Our code of conduct.
Yeah, so first thing we're doing is looking at the complaint form and the instructions. Does anybody have any?
Oh, I thought he was saying that was in here. No, I don't.
Bob, anything on the complaint form or the
Oh, I
instructions?
think it's great.
All right,
Yay.
done, you can submit that. All right, so the next question is our own internal code of ethics.
And that appears just a few pages earlier on page 483. By the way, I should state for purposes of, it's for you all to know, some of the terms in here are not necessarily terms that are used commonly, but they were used in the audit itself, and so I tried to mimic that in addressing the issues.
I like its brevity, that you have not gone as far as New York. And it appears to cover the major issues without going into great detail and off the page.
And I should say, and this is obvious, at any time, if you all decide to adopt this, if at any time we see something that we need to tweak, we can do that.
Would a motion be in order with the provision that we can, as we move along, modify it if necessary?
Sure, yeah,
Get it off the page.
I think the beauty of this is I was able to read it while we were talking. It's
Talking, yeah.
that short and it's that good, okay. I'm,
High five.
all right. Anybody else have any comments about the draft code of conduct? Are we ready to approve that? And you can submit that to the Legislative Audit Committee as a draft, and we can,
I move we approve.
Do you want to, hold on, forgive me. Are we approving it as a draft for the Ledge Audit Committee, or are we approving it as your policy?
I think we need to approve it as our policy with the provision that we always know that we can modify in the future.
okay, so it's a motion for final approval of the code of conduct. That's the motion. Is there a second?
Second,
It's been moved and seconded. Any further discussion about adopting the internal code of conduct? There's none? Roll call.
Commissioner Bacon?
Aye.
Commissioner Jones?
Aye.
Commissioner Smith?
aye.
Mr. Chairman?
Aye.
Well done. Do you know?
And thank you, the last item on the audit, so you know, I've been in contact with Trey, our auditor. There's some emails on your iPad back and forth between Trey and myself. It was not in your packet, it's a supplemental. He wants to know, well, so to speak, take your temperature, as it were, whether the commission, first of all, whether the commission still wants to go through the LAC for any legislative changes. I told him that that's still an open option, but I don't know if you guys want to do that for sure or not, and that we're working with the AG's office. He knows that. I've also sent him the decision, the Ethics Watch decision, so he has that as well. His other question is more about, if we do go through the LAC, do we have any appetite for doing a referred measure? And I pointed out to him, I'm not sure if the Legislative Audit Committee itself has any appetite for that. Was he inviting us to do that? He didn't really answer the question. He just said that we're a unique body and that that's something that we could consider. So I don't know how to respond to him. I'm happy to take any direction you have.
I don't think we have anything to offer at this time, and we can always work with an individual legislator, frankly, on even a referred measure if we decide later on, but I'd hate to commit to doing something when we don't have anything specific to offer.
Allow me, just for ease of reference, let me go get the audit report real quick, and I'll point you to the specific provision he's talking about, because there is some substance underneath it.
I don't think you need to. It'll be too fat, it'll take
Okay.
too much time. I have a elephantine memory of this. We had told them that we were contemplating holding some hearings about the amendment itself,
Yes.
with the objective of recommending potential changes to the amendment that would make it work better. I still think that's a good idea, but we don't have time to do it in the next two meetings, and we don't need to do it until, legislative referred measures, those are going to be next legislative session starting in
January.
January.
May.
Yeah, so I think we've got time to think about that. But I would like everybody to think about whether you think that's a good idea, or maybe this is just my dumb idea to hold real hearings, but I could see spending a day.
I think it would be a lot of sound and fury signifying nothing.
Okay, well,
Oh, wow, well, wait,
we may or may,
I was kind of interested. So what would that entail?
well, in my own mind's eye, I had the idea that, we who have had all this experience dealing with this, how do you hold hearings? How much do you have to keep confidential? When do you keep it confidential? That we could actually draft some improvements to the amendment, then circulate those to people like Peg and others who are interested in the amendment. Depending on what we do with home rule, there might even be a whole bunch of other people that would want to see something else, something clearer stated in the amendment about home rule. And then we could send it all over to we could hear everybody's input. And if we come up with something, we'd hand it over to a sponsor and say, we'd like to see this on the ballot.
And I would only add, too, there are also the issues that were part and parcel of HB 1216 that you all may want to consider as well.
So we're dealing with two possibilities, one statute and the other constitution.
Yep.
I think it's going to be highly problematic for the legislature to get together to propose anything to put on the Constitution, and probably highly problematic whether the voters will approve something that is put on the ballot to amend the Constitution, without a great deal of outreach and voter education.
Hence your original comment?
Yeah. Usually ballot issues dealing with this sort of thing take a great deal of organization, a great deal of persuasion, and I don't think this commission has the clout, the resources, and the friends out there in order to make that a reality in the state. But maybe
No,
I'm a pessimist.
The amendments someone would have to adopt the amendments and make them their cause, is what you're saying, and
Yeah.
pay for advertisements and go out and do whatever needs to be done to
Yeah,
get
I
a
think Ethics
constitutional
Watch would
amendment done.
probably do it for us. I'm being a bit facetious.
All right, well, I think we said that we would consider this, and we will continue to consider it.
I won't be an
I will-
obstructionist.
I will respond in kind.
But we have met our obligation to consider it, and we continue to consider it. So
Okay,
check that
very
box,
good.
please.
Other than that, I don't have anything specific for you today.
Okay.
What would you like me to do with home rule? I imagine that that's a topic you want me to bring back on the 13th.
Is it the 13th or the 12th?
I thought we said the 13th.
We did say the 13th, okay.
Does anyone have a view of that? I'm happy to put it over to the 13th.
I have no problem, Dino, I was impressed that we could just punch the button and go out on the webpage and pull up those comments. It's pretty tricky technology. I was impressed, so.
Would you also, and last question, in this vein, with September 13th, do you want me to try and schedule the commissioner interviews for that day? I mean, if we're doing home rule that day and commissioner interviews that day, that in and of itself may be a long day, and we have some pending complaints as well.
Can we do the commissioner interviews like at a lunch break, so we can not waste the public's time?
I think that may be required to happen in open session, but you can still do it during the lunch break. Yeah,
Oh, it's a public session, oh.
I think so. I'm not positive. I'd have to check.
Mr. Chair, and I got to tell you that it will be great to have the interviews, but it involves their schedules as well as ours in trying to do it. But the fact that you have interviewed all three candidates, the commission has previously acted upon a recommendation or listened to your outline of your interview with all three and actually taken action. I know you may feel uncomfortable that this is commissioner that we're going to be working with for many years, but I just want to tell you, it is an alternative that we could go to, and I'd be fine to do that if we're not able to get it done, so.
Wise advice, Commissioner Smith.
Can we get and maybe we already have this from months ago, a CV, photo, something like that? Can we get some?
Well, look, I'm not averse to that. I really wanted to make sure that all the commissioners were involved in the decision and not be overbearing about the selection of a commissioner.
Mr. Chairman, another option, thanks to Kyle, would be if you all wanted to, without violating the open meetings law, if you each of you individually calls the individuals, that is doable as well if you like. I can make that happen, like I did with you.
Can we all just individually just meet them for coffee? If we want to, if someone wanted to do that.
Wow, I'm impressed.
I said if someone wanted to do that. You see, I started backtracking.
I can help set that up.
They might want to do that. Yeah. I'd feel good if you did that, with your legislative expertise and plus a mug of coffee and told us what you found.
Okay,
You don't want to do it, you want me to do it?
Yeah, she thinks
Each
it's a
one- each
great
one of
idea if you do it.
It's a great idea if I do it. And then, how would we communicate it? We have to communicate it to Dino or,
At the next meeting, you would just, in public, share your impressions of.
And then vote?
With the
Then we could
chairman.
vote, yeah.
Oh, okay.
well, I think what we would do is we would tell the candidates that rather than trying to schedule a meeting with all of us together, individual commissioners will be reaching out to them, as I did, and that we will make a decision at our next meeting.
Okay.
And that then it's up to each commissioner, if you're inclined to interview the person, you're welcome to do it. You'll have the resume and the contact information. Dino will help schedule a call if you want to. You can just reach out to him and say, put something together. And then we'll just assume that everybody that wants to participate will have participated by the 13th, and then we'll just,
will you send us again their resumes and contact information?
I will do that.
Okay, thank you.
okay,
Okay, and my understanding,
done.
Commissioner Bacon, you're meeting personally with them, and I'm going to arrange that.
I will either meet personally with them or give them a call.
Thank you.
Okay,
Try to meet them personally.
And I may reach out and try and make the phone calls.
Yeah, we'll all reserve the.
We'll see what we can do, right?
Aside from back to home rule, sorry, jumping around. Aside from putting that back on next agenda, is there any assignment you'd give me for the time being?
We're going to answer your question after Peg tells us what to do. Peg?
Yeah, just before you blow through that agenda item, if you're not pulling some public comment or items for that. First of all, if you're going to move it to September 13th, could you reopen the time for people to submit written comments? As I pointed out in our written comments, the Denver Board of Ethics did not have a meeting scheduled in July by the August 3rd deadline. My understanding is there were other people who were not able to put something in writing in the short time period that was given over summer. So if you're going to move it over, could you open and publicize that there's more time for written comments again? Would be my first question.
Because it kind of puts the onus on you to get these late comments, you have to synthesize them and decide which one.
Can I just also say that it's a new issue in the sense that people, and we also have someone who traveled from Colorado Springs who, on this issue, who you should really hear from today, because I don't know if she'll be here in September. But what I've heard and what CML and other folks have heard too, home rule entities who up to this point assumed that they weren't subject to your jurisdiction, they're not on your email list. They didn't get this information.
You said you would actually send out a blast to all various communities because you've done a survey of them.
I'm sorry, I didn't send a blast email. I sent it to a few people I knew in Denver. I never promised to send a blast an email. Even if I had said that, it's not my job, Kyle. But the point being, if you're going to not talk about it till September 13th, I urge you to open up the record for folks who heard about it in various ways and were not able to comment.
Commissioners, just so you know, my sole way of, my most efficient way of getting that information out is through CML and CCI. Other than reaching out to individual government entities, that's really hard to do. And that's how if you all extend it, that's how I will do it. And there are people who are not members of those organizations as such.
So all the
Not
cities.
people, but governments.
And they're not required to be, right?
No.
So then there's what, 250 cities or something?
Home rule.
Oh, and what, 98 home rule?
Yep.
So,
What I'm most anxious to do is hear from the other commissioners on their thoughts and learn from all of you what guidance you think we need to put into it. That's what I'm anxious to hear.
So here's my balance, the thing I'm trying to balance here is, I do know we got a bunch of late comments.
They were timely. They came in before on the August 3rd deadline.
August 3rd, so we gave ourselves 1 week. I guess I don't have any problem having more information rather than less, and so if we want to reopen it but we should make it like August 30th deadline, because that gives us 2 weeks before our meeting, because there's a lot of these things that come in, and I don't want to be here, discussing and not having had a chance to read the comments, so I feel like it's been widely publicized. Yes, ma'am.
Let me address the commission. My name is Tracy Lessig. I'm with the City Attorney's Office in Colorado Springs. I'm also the legal advisor to the Independent Ethics Commission. The City of Colorado Springs has been working on for 2 years to amend its code of ethics. I've appeared before council twice in July to present those changes. I had no knowledge of this change whatsoever. I'm not on until I found out. Now I am on the email. I am on the CML listserv. It did not go out on the CML listserv. I actually was lucky to find out from Gary Fornander, who's a member of Common Cause, who comes to our meetings. He's the one that alerted me to this in the middle of me presenting to council our changes. The last time I presented to council, I informed them of this issue. Our current code would not be compliant. Our current recommended changes are not going to be compliant with the draft position statement. So I've had to tell council we're putting the whole thing on hold until we figure this out. So I don't know if there's another way. What I did then is I sent on the CML listserv the draft position statement to everybody on CML. But I will let you know, as the legal advisor to the Independent Ethics Commission for Colorado Springs for many, many years, I learned about this in mid-July. So,
Okay.
and maybe that's just our ignorance, but because we assume we're not subject to this jurisdiction of the commission, we don't follow the commission's doings that closely, and I'm very rarely on your website. So I don't know if there's other cities that are in a similar role as us, but that's kind of how Colorado Springs found out about it.
Oh, okay, Kyle, could you actually speak to someone at CML and
I will.
Colorado counties and either confirm that they have distributed this to their whole listserv? One. Number two, inquire whether there are significant omissions from their listserv. Because certainly all the major front range, we should be able to, with a list of 10 cities and counties, or 12 at the most, cover 85% of the population of the state of Colorado. So-
The whole population is going to be affected. I mean, I don't think we should just pick the big guys.
Well, I'm not either. I'm just saying that let's make sure we don't miss the big guys. I mean, we want to do it as effective a notice as possible,
And
and
let's
so.
not miss the little guys, because they can get paraded in here and take up a lot of our energy and time if they don't know what the rules are. And they haven't.
Maximum possible distribution, please, with the
Will do.
deadline of August 30th for any comments?
I will coordinate with the folks over at those.
All right, and post it on the website so everybody knows August 30th is the new deadline. Yes, Peg?
Yeah, I just wanted to let you know, the city of Denver knew about it, just that their Board of Ethics doesn't have a meeting in July.
Got it.
So their meeting's next week, so if you extend it to August 30th, then that should give them enough time for the Board of Ethics to be able to comment on this. I realize they forwarded it to the city attorney, so you had something on the record by August 3rd, but their Board of Ethics really wanted to be able to discuss this. So hopefully you should be able to hear from them if you extend it out to August 30th.
Okay.
Right.
All right, so we'll roll it over to September 13th. We'll extend the comment period to August 30th. Our executive director will make special efforts to make maximum possible notice, and please keep a record of it so that next time we don't have people saying, I didn't know about it, I didn't know about it.
And not just CML, if everybody's, if only the larger players were on CML.
I have a record of all the emails I've sent so far, but I will specifically call them and talk to them.
CML's generally open about.
And thank you for sending it around to all the members on this listserv. We appreciate that.
Right, so it's the CML that served. So, and I did get some comments back, so at least I made that effort to send it out. So.
How about CCI, because home rule counties?
I will do that too.
Yep, okay. Yeah,
Okay.
For giving me the opportunity to address one.
thank you.
No, thank you, very helpful. Sorry you had to wait all day for this, but
Hey, it was a good learning experience.
we don't often have hearings, so this was, everyone's a little different, so today was a little different. Okay, so anyway, apologize to the board. I suppose you can continue on if you want, but I need to leave. I did not think we'd be later than this today, so I made a commitment for 5:15.
I think we're good.
Does anybody object to adjourning?
No, I just want to know from Dino if there's anything else he has to have. Is there anything on that list? Okay. I saw you
Okay.
check.
We are adjourned until September the 13th,
Thank you.
or sooner notified if we have to have a special meeting. All right, thank you, everybody.